Lawyers of Reddit, what's your best most bad as I rest my case moment? I do mostly solicitor work, so if I'm doing my job right I don't get a whole lot of these type of moments. That being said, I had a long time client who was being sued, and I got to shut down the guy suing him in a very satisfying waypoint. So my client had hired a guy, we will call Kevin, as basically a right-hand man for his company. The employment contract wasn't done yet, but they had an agreement that Kevin would work 6 weeks at a lower wage and then sign the contract and get the agreed upon wage. So the guy works decently for 5 weeks and then is given the contract to sign. He comes back to the owner, my client, and says that he has some small changes he would like to make. When the owner gets the contract back, he finds that the small changes involve removing the duties and responsibilities section, basically the job description, and the non-compete/confidentiality clause. Not only that, but he has written in a higher salary than agreed and added a bunch of new benefits for himself. Obviously, my client tells him that he can either sign the contract as it was originally laid out, or he can find himself another job. He takes the latter option. But he starts a lawsuit against the owner wanting to be paid for the 6 weeks he was supposed to work, which had already been paid, 2 weeks in lieu of notice and 5 weeks vacation pay. I got the enjoyable job of telling Kevin, in front of a judge, that he was not entitled to anything under the employment legislation, and the only way he could get any of that would be if he had signed the contract. Judge dismissed the case and awarded costs to the defendant, but not before giving Kevin a lecture on wasting the court's time. It wasn't a trial, though we had one of those, and I won it easily. Just always stuck with me because of how clearly the law supported my position to the point that it was inarguable otherwise, and also because of how ridiculous the claim of monetary damages was. Guy moved out of his apartment, turned in his keys, then came back 15 days later demanding access so that he could retrieve belongings that he had left behind, which at that point had been trashed. It was just some minor furniture type items. Lampshade is the only thing I clearly remember, and a box of his college notebooks, that is notes he took during class. He is furious and sues the landlord in small claims for $5,000, state maximum, because his notebooks have such huge value. Apparently they hire me, and I respond, which moves the case out of small claims. It's just the way it works here. After time in r/legal advice, I know this is not the case for every state, but our rule is better than yours. But enough aside. This puts him at a huge disadvantage, because now he can't rely on the lax rules of small claims, so he goes out and hires a lawyer. The lawyer calls me to try to talk settlement. I know her pretty well, so I wasn't rude or anything, but I kind of scoffed and was like, no, that won't be happening, and direct her attention to a particular state statute, then read it out loud to her. This statute, unlike everything else in the law, isn't overly long or wordy or hard to follow. It just says bluntly that when someone actually moves out and gives notice of this, items left after 10 days are abandoned. Period. End of story. I could feel her deflate on the phone and encouraged her to dismiss the suit. She did not. We proceeded to a short bench trial in district court that we won. I have two that I like to share. I'll apologize upfront for the length of my response. The first involved a lawsuit against the owner of a Mexican restaurant for not paying his employees and keeping the waiters' tips. He was just a terrible all-around guy. He created these fake handwritten schedules and payroll records going back years to try and prove that his employees didn't work but a few hours each week and were paid for what they did work. It was difficult to prove they were fakes, but we managed to trap him during his deposition. I made the guy go through random bits of his work schedule and asked him to confirm they were correct. We did a random week in February, March, April. Then we got to May. So, here in early May, you had 2 servers working every night, 1 hostess, 1 bartender, and 2 cooks. Yes, and that didn't fluctuate. You didn't have a need for extra staff on, say, weekend nights. No. It was very steady, no matter the day. What? About on this Wednesday? How much staff did you need? Just the 2 servers, my hostess, the bartender, and 2 cooks. The same as every other night. And if you would indulge me, what date are we looking at? May 5th. Okay. So it's your testimony under oath that you had the same staffing needs on May the 5th as you did on May 4th and May 6th. Yeah. Opposing counsel's head begins to hang while shaking. So, you are comfortable telling the judge you didn't do extra business on May 5th, yeah, or June 17th, or whatever date you pick. It was always steady. You have no problem walking into court and telling the judge and the jury, under oath, that your Mexican restaurant didn't need any extra help on May 5th. That these schedules and payroll records you've produced are 100% accurate. For Cinco de Mayo, you are totally comfortable with doing that, yeah. The case settled within a week. Story 2. State law enforcement was trying prosecute a local cop for accessing name and address information for an individual in the state's criminal justice computer system to help a friend who was a process server. The state was prosecuting the cop for violating the Computer Crimes Act, which, in part, makes it illegal to share any information which the state has an intellectual property interest in. We show up for trial, having waived our right to a jury, and allow the head of the Attorney General's litigation department to make this wonderfully colorful speech about a police officer breaking the public trust and this other nonsense. For our opening statement, we move to dismiss the indictment on the grounds that the state's theory of the case is a legal impossibility. The state cannot have an ownership interest in someone's name or address. The judge was annoyed with our tactic and put the screws to us by asking dozens of questions, but we kept repeating our theory: the state cannot own a name or address as intellectual property. Finally the judge gets it and turns to question the AG. He tries to dance his way out of answering the big question all sorts of ways. Eventually the judge flat out asked him if he contends the state can own someone's name or address. The AG responded by saying, "Judge, I came here to try a case, not to argue the law." The judge was not impressed and dismissed the case immediately and wrote a letter to the Attorney General asking him to be more selective in his prosecutions. That was a fun day in court. I know, and I've told this story before, but it always makes me smile. Wall of text incoming. I was in court to get more placement for my 2 kids. My ex-wife and her sister were claiming all sorts of things, that I was abusive and a stalker and a rapist, and on and on and on. Like, to give you an example of what they were pulling, they claimed that I choked my daughter, and then they brought her to the doctor in October 2016. The doctor brought in a second doctor and they both looked at these marks on her neck and were like, "We can't exactly call the police for this because it's unclear." I pulled the doctor's records and the appointment never even happened. So there were a few moments. One was that they were claiming that I angrily hauled my son out of their house because he wouldn't put on his shoes or coat in the wintertime. Now, while I did take him out of the house, it was because they had been arguing for 10 minutes with a 4-year-old about putting on shoes and a coat in winter. They had only gotten his shoes on, so I picked him up and took him to the car. Then he stopped me and wanted to put on his coat. So this was their big moment. He looked so angry and hauled son out of the house. My attorney has my ex's sister on the stand. She's already unsteady on the stand, muttering and not answering questions clearly, and trying to lie without lying. So my attorney asks, "Why did you think it was unnecessary for Bruce Lee 1255 to carry son out of the house?" She says, "Because you can reason with son. He's 4. You really think you can reason with him?" Yes. So, in this case, did it work? She froze, like literally froze. For about 5 seconds she didn't say a thing. 5 seconds doesn't sound like a lot, but when you're on the stand and everyone is staring at you, it's interminable. Finally she said, "Well, it usually does, but, in this case, did it work?" "Well, it usually does." He moved on. But the best part, and the one where I could have flown, was toward the end of the trial. So, my ex spent 8 hours spread out over days ripping apart my character. I was a rapist, an abuser, violent, but also one time I sent my daughter home with dog poop on her shoe. Murder, arson and jaywalking is what we called it. Like, if he's so violent, why are you even complaining that one time she had dog poop on her shoe? Anyway, so, after all this time, she still never explained why she thought my daughter couldn't have more time with me. She made a lot of hints, but never nailed down any reasons in any communication she sent to me. Even in her deposition, she didn't say anything about abuse. So, finally my attorney nails her down on the last day and she says that she's afraid that my daughter won't know that mom is going to come back. Basically, that my daughter lacked object permanence. The judge asks her a few questions. He says, "So are your son and daughter close?" "Oh, yes, very close." "Does daughter miss him when he goes to school?" "Oh, yes, very much so." "So, does she miss him because she loves him, or miss him because he's not coming back?" "Oh, she knows he's coming back." Okay. In the span of a minute, she torpedoed her entire argument. Her attorney saw it right away, but she didn't. They tried flailing around in the closing arguments, but it was all over, and I got more time with my children. Two high school kids spend their day pissing each other off, so they decide to drive to a fast food restaurant to fight. They park, get out, immediately approach, and swing. Kid A connects the first blow squarely and solidity across Kid B, and instantly drops him. The whole fight was one punch with a total elapsed time of a few seconds. The restaurant is sued for failure to protect its patrons. The case is weak. Unfortunately, Kid B hit the pavement hard and had severe brain damage. Attempts were made to settle, but they were after millions. We knew walking, and they had two former employees testifying about large crowds building up after school. The plaintiff attorney aimed to prove the restaurant had a reasonable expectation of trouble and should have had armed guards in the parking lot. Point at best, their witnesses wildly exaggerating to the point of perjury. Their credibility was shaky, in being highly disgruntled for being fired. We had a list of witnesses ready to refute their claims at trial. The plaintiff attorney presented first. He spent a long time building up the bad blood between the kids, the serious damages of Kid B, and his potential earning capacity. A lot of foundation work to build sympathy for his client. We break for lunch on day 2, after which it would be the defense presentation. As we were talking through where we were and how we should proceed, we realized the restaurant was not really mentioned at all. Plaintiff held back his star witnesses to rebut the defense presentation. The restaurant was safe. So when we reconvened, defense rests, Your Honor. The plaintiff attorney fell out of his chair. He begins frantically shuffling papers on his table and was stammering. The judge says, "I take it, you will need a few minutes for your close." After that break, plaintiff's attorney gave one of the worst closing remarks I've ever heard. Point jury, Kid B 10% at fault. Kid A 90% at fault. Restaurant 0%. I was a second-year associate and handling my first trial. I represented the plaintiff. The defendant had an expert witness who had testified previously in about 40 similar cases. This expert came out to my client's property and did a completely bullshit examination of the issue, and his expert report was equally as bullshit. For those of you that don't know, expert testimony needs to meet a certain standard, the Dorbit standard, at least in my state, in order to be admissible. This guy basically took some photos and put a ruler on the ground a few times to make his report seem legit. The partners at my firm told me it wasn't worth trying to file a Dorbit motion to strike his report/testimony because the case was low value, under $100K, and those types of motions can be very complex, and didn't want to bill the client for it. I was so angry about this guy being deemed an expert that I came in on a weekend on my own time and drafted a 20-page motion to strike his testimony. I didn't bill the client a dime. Point, the defendant didn't file a response to my Dorbit motion to strike. Instead, they waited until right before the expert was set to testify. He had been sitting in court racking up fees for 2 full days beforehand. The judge had the jury leave the room, put the expert on the stand, and allowed the defendant to do a direct examination of their expert. The defendant's attorney, not taking my motion seriously, had their inexperienced associate, just like me, do the examination. It was incredibly basic and didn't respond to any of the points in my motion. I was in charge of doing his cross-exam. It was my first cross-exam of a witness ever. I tore the guy, a seasoned expert witness, apart on the stand. I got his entire testimony and report struck. They also had a second expert witness who was pretty terrible, but not quite as terrible. I also did his cross-exam. Realizing that they were in serious trouble without their primary expert, and their second expert at risk of getting struck, the lead counsel for the defendant, a named partner at a well-known firm, did the direct exam for the second expert. I again did the cross. I got the second expert's testimony struck except for one very tiny area. So essentially he was forced to testify with both hands tied behind his back. It was the most gratifying moment of my legal career so far. I represented a man in a slip and fall case in a national chain that grills chicken. The restaurant is not supposed to clean the grills until after they close because it is a huge sloppy mess that involves using a garden hose after applying chemicals to remove all of the grease. The close down process can take up to 2 to 3 hours that involve packing up the food for the next day, scrubbing the grills, mopping, etc. Even though the corporation knew this, they refused to pay more than 1 hour worth of wages after closing time. Thus, the shift managers and cooks decided that they would start the closing process 2 hours before closing, while there were still customers in the restaurant. This is really dangerous as employees delivering food can track the greasy water into the lobby where the customers were. On one fateful day, 2 hours before closing, one of the cooks was cleaning the grills and using the hose to wash them down. This slurry is so slick that the cook has to wear a plastic smock and slip resistant shoes for the process. While he was waiting for the chemicals to remove the grease, which takes about 15 minutes, the cook goes into the lobby tracking this stuff into a hallway to wipe down some tables. My client walks out of the restroom and slips in the greasy water. He hits his head so hard that it causes a subdural hematoma, which requires surgery to relieve the swelling and blood from the brain. Go figure, the video system wasn't working that day. In any case, right after that the cook was fired and the corporation claimed that they could not locate him during litigation. I did some research and found a relative of the cook, which eventually led to me finding him. He admitted that he was cleaning the grill, but denied that he was the one that tracked the greasy water into the lobby, as did all of the other employees. The corporation during the entire 3-week trial testified that cleaning before closing was against their policy and it never happens. Thus, it had to be anything else that caused my client to fall. I was talking to the cook before trial because we were going to call him as a witness. He was pissed that they fired him. I asked, "Do you think they are still cleaning before closing? Because they are denying that they do." He told me, "Absolutely." On the first day of trial, I sent my investigator to the restaurant at the time my client was injured, which was 2 hours before closing, to record video on his cell phone, whether they were cleaning or not. Guess what? They had the hose out and everything. I couldn't believe that they would continue to do this at the restaurant at issue in the case. I told my investigator to go back up there when there is a different shift manager and cook to see if they are doing the same thing. They were. At the end of the trial, the defense put on their general manager for the region. He swore up and down that this never happens. He was their last witness. We get up and say, "Judge, we need a sidebar." In the judge's chambers we revealed the videos to the other side. The attorney for the corporation was freaking out. The judge let it in for rebuttal. The last thing the jury saw before going into deliberations was 5 minutes of video with audio of the hose as they were cleaning the grills 2 hours before closing. We completely wiped out their entire defense in a 3-week trial with that video. Needless to say, we prevailed. I should add, using sub rosa video against a defendant like this is very rare. They usually stop doing what they are not supposed to be doing during the trial. I guess the restaurant didn't get the memo. Edit. Typos/correction. This isn't an I rest my case moment, but it was a damn fun cross-examination. I was defending an alimony case, and in my state cohabitation with a new lover is a bar to alimony. We had had a pie on the plaintiff's tail for a few months and she and opposing counsel had no clue. I had a mountain of evidence that the plaintiff had moved in a new boyfriend and they were essentially husband and wife without the marriage certificate. So, if I could prove cohabitation, she didn't get alimony. On cross-examination, I'd set her up with a question I knew she'd lie about and then hit her with a photo contradicting her. "So it's your testimony that John Doe never visited your house?" "Oh, so do you have an explanation for why he's walking in your front door in this photo?" "So he did come over, but never stayed overnight?" I see. Do you have an explanation for why his car was parked outside of your overpass on X, and X nights as seen in these photographs? For a solid 45 minutes to an hour I'd ask a question, she'd lie, and then I'd impeach her with a photo directly contradicting her. I was catching her in a lie per minute or more. She never wised up either. After the first few times you'd think she'd tell the truth knowing that I'd just catch her in another lie, but nope. She just kept on lying. Again, it wasn't the flashiest or even an I rest my case type moment, but it's the most fun I've ever had on cross. In the subsequent order the court made the specific finding that the plaintiff's testimony was without a. Several years ago there was a big drug bust in my town where the cops arrested about a dozen people in this garage and charged them with manufacture/delivery/possession with intent to deliver a controlled substance, drug dealing, conspiracy, and criminal organization, known as RICO in other places. I was appointed to represent one of the people found in the building when the drug task force raided the place. The police filed an 8-page affidavit of probable cause, most are 1 to 2 pages for most other cases, detailing their surveillance of this criminal enterprise and the comings and goings of various participants and their roles in the enterprise. I read all 8 pages and realized that the only place my client's name appeared was on page 7, where it said the following individuals were present at the garage when the warrant was executed: Person 1, Person 2, Person 3. So he was there the day the drug task force raided the place, but there was no mention of his involvement in the criminal enterprise. His bail was set at $250,000, which is ridiculously high, and the district attorney refused to agree to a lower amount at his preliminary hearing. I filed a motion for bail reduction and showed up at the hearing loaded for bear. The DA calls the case. I approach the front, and the judge jumps right in before I could even open my mouth. Usually counsel makes their arguments first. The judge asks any questions of us he has, then he makes his decision. The judge looks directly at me and says he's read the affidavit of probable cause. He says what is alleged in there is pretty serious and a big deal in our small town. He noted how the task force had the place under surveillance for weeks to build their case, which ultimately resulted in their aid. And if the allegations can be proven, the defendants are facing some serious consequences. But he says, now turning to face the DA, he saw that my client's name appeared only once in the entire affidavit, and it makes no mention of his involvement in the drug enterprise. The judge asks the DA why shouldn't I grant defense's motion for bail reduction? The DA stammers, we have no evidence that this defendant was involved with picking up the material from Philadelphia and transporting it here. The judge looks at her again and says, did I miss that in the affidavit? She replies, no, they just recently found that out. The judge turns to me and asks me if I have anything to add. There I was, fully prepared to make this passionate argument for why my client's bail should be reduced, the deficiencies in the affidavit, my client's advanced age, his lack of a criminal record in the past 20 years, etc. I stood there trying my best not to smirk and said, I have nothing to add, Your Honor. Motion granted, bail reduced. I was helping a client gain custody of his infant daughter. He insisted that baby mama was on drugs, and his first attorney tried in vain to get him to understand just how favorable our state is to 50 over 50 time, unless he can prove by a pretty high standard that she was on drugs. The problem is that he kicked her out because he had suspicions, but then one day found needles and a substance in the other baby daddy's bedroom. This was all wrapped up in an old dish towel with a band, the type you put around your arm for shooting up, name, and a spoon. She tells him every faking lie, don't know, not mine, only tried once, etc. But he refuses to believe her and kicks her to the curb. So he fires first attorney and hires me, and I go straight into client control mode, heavily managing expectations while doing everything I can to put requirements in place to catch this drug use, and we are getting nowhere. The trial problem we have is it's a one-time thing. She's a good liar, even by legal standards, and we have nothing current to show a pattern. But he insists, so I file to restrict her time and we go to court. She's such a good witness and the judge buys every bit of it. On cross she testifies that she only ever shot up the one time ever, and that's the only time she ever used anything illegal, and she just knew how to shoot up because she didn't know. I thought I had a pretty good cross. It took some time, but I felt like we got what we needed. But we lost, and the judge gave her essentially 50/50 time, ordered us to mediation, and set up some regular drug screens. We go to mediation and put in place a parenting plan that sets up a little more detailed 50/50 custody schedule, but also requires regular urine drug screens and some more detail about those screens, so we can be sure she isn't constantly trying to beat the tests. Best I can do with the facts. I caution him that all we can do is pay attention to the screens, stay on top of it, and take her into court under an emergency motion at the first slip-up point. But she is so good. She's supposed to take the screens within 24 hours of a request, but always has an excuse and is just a couple days or so late. Also, somehow almost all of her screens are on Wednesdays. Later find out a friend works those days. Also, mysteriously, she refuses to give me direct access to the screens, but provides them to her lawyer who faxes them to me. I immediately start sending faxes. He was old school, no emails, and an asshole, so no phone calls, and telling him I consider this contempt, and he better cure it, or I will file. My client is furious at each contempt, but the standard for this is so high, and we've already been in court once, and didn't do well. So I really needed to build a case point, so finally we get quite a few weeks of ridiculous behavior. And my more than reasonable attempts to address it with her attorney. I file for civil and criminal contempt, and we go to court. Point an important detail is that she has another baby daddy who was fighting custody at the same time for the same reasons and has required drug screens. I'd been in contact with his attorney and we were sharing information. I find out that the night before our hearing she had completed a urine drug screen and passed it. So when we get there I caution my client about getting his hopes up. Remind him this is a long game. She's late and judge starts without her. No facts given. Her attorney surprise withdraws. He says it's because of lack of communication. She finally shows up as I'm giving the rundown of my motions. I run through the timeline of missed screens, delayed screens, a screen that failed because her sample was too diluted, etc. And the judge looks at her, and she gives all the excuses in her very sweet and innocent way. The judge listens, then asks how she would test that day. She says she will be clean. So they screen her. And she fails for exactly what we expected. The judge asks why, and she tries what are clearly excuses this time. Changes her story to fit the facts, and he cuts her off and tells her he doesn't believe her. He orders her to 4 hours a week supervised visitation, and she has to pay dad support until she completes an intensive outpatient drug treatment program, at which time she can regain some of her custody. Point that little girl just turned 5 and mom has never visited, and to my knowledge, has never completed any treatment. She also hasn't paid a dime, which my client doesn't care about, and doesn't care to pursue. Point it's a small town. He said he saw her in a restaurant once, and she walked right by her daughter, and didn't acknowledge her. I've seen her out once with friends partying without a care in the world it seemed. Point sorry for typos and if garbled. Had to get in before my plane takes off. I've had a couple such enjoyable moments, though they have all been no further questions moments, as I rest my case is not something I get to say in family court. I apologize in advance for what is likely to be a pretty lengthy post. Point in the first ever domestic violence restraining order, DVRO, case I had as a new attorney, I represented a woman who has broken up with her ex-boyfriend after he has shoved/hit her. She filed for a DVRO when he continued to harass her and show up uninvited to her place. The process for getting a DVRO, at least in my state, is the victim files documents describing the alleged abuse, and a judge decides to grant a temporary restraining order, with a hearing scheduled within a couple weeks, where each side can present their case. Even after my client got the temporary restraining order, her ex continued to try to contact her, including randomly showing up where always she took her dog for a walk at 5 AM the morning of the hearing, even though this was 25 miles away from where he lived. At the hearing, even before either party got to testify, the judge reiterated that any violation of the temporary restraining order, including attempted contact with the victim, was grounds for a permanent DVRO being issued. The judge ended up ordering a brief recess before we were to introduce evidence/testimony. During the recess, my client went to the bathroom, and the ex decided it would be a good idea to follow her into the bathroom to talk her out of pursuing the DVRO. He had not noticed that the bailiff was also using said bathroom, and the bailiff immediately ordered him out of the women's bathroom and threatened to arrest him. When we got back into the courtroom, X took the witness stand to testify. I asked him if he had just attempted to enter the women's restroom to make contact with my client. When he answered affirmatively, I smugly stated that I had no further questions. The judge tore him a new one, and the DVRO was immediately ordered. On one other DVRO case I handled, I was defending a husband who was accused of completely unsubstantiated and clearly fabricated abuse by his train wreck of a wife. My first question for the wife, when she took the witness stand, was, isn't it true you made these allegations and are requesting this DVRO solely for purposes of gaining an advantage in custody and support proceeding? I obviously assumed she was going to deny it and was really just planning to try to get her angry on the stand so she'd slip up and give inconsistent or conflicting testimony. When she answered yes, the judge looked as surprised as I was. I immediately stated that I had no further questions, despite the fact that I had prepared at least 40 to 50 questions for her, and sat down. The judge tossed the case moments later. A lawyer friend of mine had this scenario. His client moved into a newly built office building where they got to do a fair amount of construction work to arrange the offices on their floor how they wanted. As it turned out, there was this overly large gap between the lip of the elevator door and the floor, on the order of an inch or so. You wouldn't think that's enough for an issue, but it was leading to people continuously tripping themselves up. So, since they were doing construction anyway, they paid someone else to do a small concrete pour to smooth things out and fix the problem. The original construction company finds out about this and uses their technically unconcluded contract to insist that they can rip up that floor and fix it themselves. They do so, and now instead of a small issue next to the elevator, the entire surface of the elevator lobby on that floor is ruined. Random +/-half-inch dips and hills all over the place. There was basically no leveling of any kind done. Upon being told that this was unacceptable, the construction company responded by sending the client a bill for the first redo that they hadn't wanted done since they'd solved the problem, and a quote for fixing it. The timeline of these events was presented to the court, and then an extremely scientific presentation on just how truly horrid this floor was, with high-resolution topographic maps of the surface presented, clearly showing just how bad this floor was. And then the lawyer, while talking with the lead engineer for the construction company, leans in and asks the question, is this acceptable work for your company? The reason this is such a mic drop is that it is handing the construction company a win, but at great cost. If they say yes, then the client has to pay the first bill and would have to pay for a redo, but then the lead engineer of that construction company goes on public record as stating that shoddy work is considered acceptable by the company. If they say no, then the construction company eats the cost of the redo and the redo necessary to fix it, and goes on record as saying they screwed up. Not a lawyer, but was working with our corporate lawyers on a patent infringement case. I was an engineer specializing in the technology in question, a document scanning system. At the time, we had a relationship with a company that provided OEM products for our lower end scanning market, and in the meantime we were working on a higher end machine of our own design. As our new design was getting ready for market, they accused us of violating one of their patents. The wording of the patent in question was very broad, and it indeed looked bad for us. They invited us to their HQ to discuss the issue and potential remedies. Best case, licensing fees. Worst case, back to the drawing board. We had met several times before the trip to prep, and despite the efforts of our engineering team, we could not find a hole in the patent. We flew out to their HQ, and upon landing, met one more time in the hotel lobby. We were prepared for the worst. It was then that I noticed some wording in the patent that was quite specific about the way that the document scanning surface was held in place while the scanning head moved. Their patent described the surface resting on fixed rails, with the scanning head moving beneath it. However, because we were very concerned about maintaining a constant focal distance from the scanning head to the document, our scanning surface was captured by the head itself, not the rails, so that the document surface would freely track any minor up and down, or twisting motion of the head due to rail deflection or dirt, or what have you. In fact, if the head was not present in the machine, the scanning surface would just fall into the bottom of the unit point. Well, the lawyers looked at me in shock. We talked it through, and they started grinning, and soon we were all smiling like idiots. It was bulletproof. We went into the meeting. They had their corporate lawyers, engineers, and business sector managers, and after all the righteous outrage was expressed, along with the desire to somehow find a way forward and maintain a good working relationship, blah blah blah, it was show and tell time. Our lawyer simply said, we don't believe that we violate your patent, and using the prototype that we had brought along, I showed them why. It was beautiful. They just sat there at first, then their technical guys asked me to show them again, then they left to have a private conference. We just tried to keep it professional while we waited, but we knew we had them. They came back all apologies, saying how they hoped that our fruitful partnership could continue as it had been so successfully before, etc. When we left, we went straight to a nearby bar and celebrated. By the end of the night, our straight-laced corporate attorney was all, I love you guys, man. It was a great day. I worked in the legal department of a public school district while I was in law school. Because of changes in the laws regarding the foods and snacks that could be made available to students, for instance, sugar content, the district was seeking to renegotiate its contract with one of the food/beverage vendors. The contract was with a local subsidiary of a global corporation that you have definitely heard of prior to the end of the contract term. The other side took this contract so seriously that they sent an attorney from their home office to meet with us in our office, and he threatened to take the school district to court for breach of contract as they did not want to renegotiate the contract or change the terms. He was apparently not accustomed to dealing with school districts or any kind of governmental entities for that matter. My boss, the general counsel, had asked me to figure out how to get the district out of that contract. So I researched state law regarding contracts with governmental entities as a starting point. Since the school district was established under state law and was a state governmental entity, it was also, by law, immune from lawsuits for breach of contract. It was extremely satisfying to point out to him that we were immune to such suits, but that he was welcome to attempt to bring one and be laughed out of court. We later negotiated a new contract that was favorable for both parties. I'm not a lawyer, but a few years back I was sued by an old landlord. It went like this. About a year after I moved out, I was contacted by a collection agency saying that I hadn't paid last month's rent. Instead of looking into it at the time, like I should have, I sent a check directly to my landlord and thought nothing else of it. A few years after that, I was contacted by an attorney saying that I had to appear in small claims court for an unpaid bill. I reached out to find out what I was supposed to have not paid. It was the same damn bill. On top of the bill they add legal fees, court costs, late payment fees. $1,200 turned into over $5,000 on this claim. It was nuts. This time I do my research. I go to my bank and find every single signed check from the months that I lived there. I was only there a year. I noticed at this time that when I paid the unpaid rent that I was put into collections over a few years earlier wasn't needed at all. I had proof that I had paid 12 months of rent, a security deposit that they never returned, on time every month. I immediately panic and think, shit, they have been putting this against my credit all these years. I had for a credit report and nothing was there. I'm good at paying my bills the week before I'm in court. However, they start putting past due payment against my credit. My credit tanks. I attempted to reach out to them several times to let them know that I had paid and I could prove it. They never responded. So the day of the hearing arrives and I'm waiting for my turn and this slug of a human calls me aside. She seriously looked like Roz from Monsters Incorporated. I assume she's with the courthouse or something, so I go over. She's the lawyer trying to collect. She hands me a piece of paper saying that if I lose today, that I'll owe as much as $10,000 and they would make it all go away if I agree to payment 15 payments of $150. I said no thank you and walked out. We are seen by the judge, and she talks for what seemed like hours about how I was an irresponsible tenant and the hardships the landlord had to go through to get paid. She droned on forever. I was fuming. Then it was my turn to speak. I handed in the paperwork that I had, which showed that I had paid for all 12 months as well as my bank statements showing they cleared payments, and sat down. The slug didn't know I had this information. She was white as a sheet. I also informed that judge that she had taken me aside and tried to get me to pay them directly without seeing the judge. The judge was livid, chewed her out for a solid 3 or 4 minutes. This was really an aha moment about stereotypes. Our client was a Spanish-speaking young man from Ecuador who had come to the US on a visa for a job at an orchard in Florida. He also ended up working weekends in construction, where his hand was cut off in an accident. We sued the manufacturer of the equipment. At trial, defendant's lawyer sneered at our client about his estimated damages and asked about his education and work history. The client testified that he took college courses in Ecuador before coming to work in the orchard, and that his goal was to be a full-time computer analyst. Defendant's lawyer: you may have been working in Ecuador toward becoming a computer analyst, but the fact is that up to the date of your accident you only held minimum wage jobs picking fruit and doing construction work in the United States. Isn't that right? The client: no sir, I was in charge of the computer system at the orchard. I never picked fruit. There was silence in the courtroom for a moment. We won. The jury awarded $2.5 million in damages, and, just to clarify for those who don't already know, damages are often calculated based upon a plaintiff's potential lifetime earnings, which is why it matters whether an accident prevents you from earning minimum wage or whether it keeps you from a job with the potential for much higher earnings. We couldn't rest our case. But it sure was a wake-up call for defendants who had never considered this possibility. I have a couple good ones. One was when I was a judicial extern over the summer. My job was to read and summarize moving papers in family court and make a recommended ruling and summarize the law behind it. They're all just called orders to show cause for. Unless there's an actual motion to compel or an emergency, most family court parties in LA County represent themselves, so the moving papers are always informal. For instance, dear judge, I'd like custody of Sally on extra day a week. Dear judge, I lost my job and I can't pay this much child support etc. One rubbed me the wrong way. It went something like, dear judge, I would like to have my daughter overnight on Mondays so I can take her to school on Tuesdays because I don't work until the afternoon on Tuesday. I told the judge something didn't sit right. We had no record of this man having a job and his ex opposed the change. So my recommended ruling was to deny. Judge disagreed and said he'd at least let the man argue his case in court. They show up the next day and mom explains that she can't change the custody arrangement on Mondays because she works and can't do drop off those evenings. She's being reasonable and wants her kid to have a dad, so she suggests they do Tuesday or Wednesday nights instead. Judge says that sounds fair. Dad says, oh no judge, my gang meets at my house on those nights. It's not safe. Judge then turns around and removes custody from his home entirely and arranged supervised visits only. Gangbanger dad then tries to jump over the courtroom table and attack the judge. We're all ordered to duck and cover and gangbanger goes away. In cuffs he went from almost getting an extra day with his kid to no custody and being arrested in all of 5 minutes. I told the judge something was off. This one ended up way too long, so I'll save the other story from a civil trial I did for later. TLDR, I got a guy off who was facing a 5-year prison sentence by asking the alleged victim whether she kept a toothbrush at his house. I had this client Gene, and I represented him in 3 child support matters. Yep, 3 different moms, 2 dependency matters, like child protective services, and at least 4 criminal matters. Gene didn't have any money, so when he got in trouble, he'd ask the judge to appoint me as his attorney. Gene was a combat vet who did 4 or 5 tours in the Middle East. He was completely broken by the experience. And the vet just screwed the guy over and over again. So one day I get a call from Gene. He's been arrested for domestic abuse. He's alleged to have thrown objects at his girlfriend, plates, a vase, beer bottles, etc. Gene has 3 prior assaults on his record including 1 domestic, so instead of looking at probation and a week in jail, Gene's now looking at going upstate for 5 years. Gene tells me the story. He picked up Veronica at the bar a week before he was arrested. Veronica was married and lived in a house behind Gene. And for the week before he was arrested, Veronica was hopping the fence to run over to Gene's house. She'd get loaded and then hop the fence again before her husband came home. According to Gene, they'd made out and stuff, but they'd never had such point in Iowa. The domestic element of a domestic abuse claim requires that the parties live together, have a child in common, were once married, or are currently having such point. So I got myself appointed to the case, and I moved to have the state pay for expenses related to deposing Veronica. I scheduled the deposition with the county attorney. Prosecutor, Veronica had been telling the county attorney that she and Gene were in a relationship. When I sit down to depose Veronica, I ask her 2 questions. Have you ever slept with my client? Do you have a toothbrush at my client's home? She answers no to both. I take a break and have a chat with the county attorney. She agrees to let Gene plead out to a disorderly, a $65 fine. That was the shortest deposition I've ever taken. I know, but I saw the best court moment ever. So there is this person I know that was charged with murder. He was very young and is on the spectrum. After several hours of interrogation, he gave a false confession. The confession was complete sheet and contained details that were easy to prove as false. The defendant's lawyer is questioning the detective that was involved in the interrogation. It comes out that the detective attended a training course on how to interrogate suspects just 3 months before the defendant was arrested. The detective was supposed to learn a specific technique that prevents false confessions. This technique was clearly not used when the defendant was questioned. L. So, you learned specific technique but didn't use it. Did you not really learn the technique? D. I don't understand the question. I learned about specific technique at the training course. I know how to use specific technique L. But you didn't use it. You are aware that the style of interrogation you used leads to false confessions. D. I don't know what you want me to say. L. So did you forget something you learned 3 months ago? Or did you purposely not do what you were supposed to because you wanted the defendant to be guilty, no matter what the truth is? D. I don't understand the question. L. Are you bad at your job because you are incapable of learning, or is it because you don't want to find the real culprit? The lawyer backed the detective into a corner for 5 minutes of what I'll paraphrase as, are you stupid or are you corrupt? There was no other option. Eventually the lawyer took pity on the dumb cop and let him get off the witness's stand. The defendant was acquitted. Not a lawyer, but I made the stenographer laugh. I was an expert witness in a patent lawsuit. It was just a deposition, not a courtroom. I was representing the ad department and just answering mundane questions on backup policies, server names, and other boring details. Opposing counsel hadn't prepared well and was asking lots of nonsensical questions. My company's counsel had prepared me well and told me to just answer the question asked with no additional details. We'd been going along for a while with mundane questions and truthful but useless answers, since they were asking the wrong questions, and the other attorney asked what was the difference between server X and server Z. I answered about 3 feet. The stenographer and several other people in the room laughed. What the other attorney was trying to ask was the difference in function of the 2 servers, but since they were used for identical purposes, the only difference was physical location. At the end of the deposition, the opposing attorney was really frustrated since they didn't get anything useful, but that's their fault since they'd asked the wrong questions. I had information they would have liked to know, but they didn't ask the right questions. The patent lawsuit ended up being dropped a few years later since it was bogus, like most patent lawsuits. For once I have a relevant story. Many years ago, my girlfriend at the time had an ex who was a total douchebag. She breaks up with him and he starts harassing her for money that he spent on her for dates and such. Nothing extravagant, but like half the dinner he paid for kind of nonsense. He was friends with another girl who was a law student at the time at a local grade deal or school diploma mill. Let's call her Nancy. They run into us one night in a club and Nancy starts going off on my girlfriend, how she is about to be a lawyer. She is super well connected in the legal community and is friends with big shots in the local community like this guy we'll call Tom. She proceeds to tell me how Tom works at the most prestigious white shoe law firm in the city. Nancy says my G/F must pay back douchebag his money or she is going to get Tom to rain legal fire and brimstone upon her. Now what Nancy doesn't know is that I'm a lawyer. Not only that, I also happen to work at white shoe firm and Tom is a friend of mine. I casually explained this to her and the fact that I'd just been in Tom's office shooting the breeze a couple hours ago. I don't recall your name ever coming up, and why don't you tell me exactly who you are so I can go relay this conversation to Tom tomorrow morning. And here is my business card to prove to you what I'm saying is true, and I'll be pleased to continue this bullshit conversation tomorrow and we can talk about your fitness to practice law as well. You've never seen someone turn so white, apologize, turn a 180, and get the fuck out of there as fast as she could. It was glorious. That girlfriend is now my wife, and I'm pretty sure this moment is why she married me. Dewey case. A little background. This would have been my client's second Dewey, and in all fairness, she was impaired at the time and wasn't supposed to be driving either. However, my client was being stalked by a local cop who wanted to date her. Officer gets on the stand and says he pulled my client over because her license plate lights were out at midnight. Goes on to further say that he approached the passenger side, where he then was able to identify that the person driving the car was ex. He smelled an odor of alcohol and pulled my client out of the vehicle for field sobriety tests, etc. etc. Arrests for Dewey point on cross. I just said, well, let's just watch the dash cam from your patrol car, as everyone in the courtroom sees that the officer had followed my client for about 2 miles trying to find a reason to pull her over. License plate lights fully illuminated. After the judge see that, he says, I assume you have a motion to make, and I reply with, well, in a moment, but in the interests of justice let's keep watching. Once the officer blue lighted my client, the system automatically turned on his MIG lapel and synced it to the dash cam footage, so we all got to watch as he walked straight to the driver's side and said something to the effect of, hey girl, I saw you the other day in your yard, still looking good, when are you going to let me take you out? She replied with I'm still engaged. As I replied with get out of the vehicle, you're under arrest for Dewey. I said. No further questions. In a courtroom which is packed. You could hear a pin drop. Then all hell exploded as the prosecutor stands up and yells objection. The judge is red in the face and orders the bailiffs to arrest the officer for perjury and contempt of court and to call his commanding officer. To get there right now, the officer on the stand starts to struggle with the bailiffs and gets tackled and handcuffed. I turn to the judge and ask if we are free to leave, and he bangs the gavel and says not guilty. Long story short, officer was charged and convicted criminally of perjury and resisting arrest, lost his job, and all his pending cases were dismissed because a court deemed him an unreliable witness. I have more stories like that. Many more. I love my job. My first ever jury trial. I'm a public defender, by the way. I represented a guy charged with domestic violence for allegedly hitting his girlfriend with a hammer. He could have been charged with F2 felonious assault, but the prosecutor kept it at an M1. We go to trial. Alleged victim takes the stand. My first question for her on cross, you're a convicted liar, correct? Her. No. In fact, yes, she was. About a year or two prior to this case, she was convicted for falsification. That is, she lied to the police when she made a report about her then boyfriend beating her up. My client, of course, knew about this, alerted me to it, and I made sure to have a copy of her conviction with me at trial. I of course shared that with the prosecutor, who still declined to drop the case point, so I show her the conviction on the stand. She confirms it's accurate. So you are in fact a convicted liar, right? Her. Yes, me. In fact, you just lied to the jury a minute ago about not being a convicted liar, right? Her. Yes, I probably could have stopped questioning her then and there, but of course I had further questions. like the fact that she called the police at least a dozen times while the case was pending to report my client was on her property, banging on her windows, and even underneath her front porch on one occasion. Mind you, my client was in jail that entire time while we waited for trial. The alleged victim was legit nuts. One night, she called the cops 4 times. Each time the officers had to explain to her, "It's not possible. He's in jail, ma'am." Also, the allegation that my client hit her with a hammer? Yeah, she had a minor contusion on her left cheekbone. My client testified very credibly that the bruise came from her picking up the hammer, him grabbing her hands before she could hit him with it. They wrestled over it. He let go while she was still pulling, knocked herself in the face. Her injury was definitely not consistent with how she testified that my client violently swung the thing into her face point. But, yeah, the convicted liar thing on cross was fun. Client was found not guilty after less than an hour of deliberation. We were in mediation on a case and were close to settling, but we were just far enough apart that it looked like it wasn't going to resolve. The mediator comes in and tells me the vice president of this company I deal with all this time, who was this like 270-pound burly guy that my associate swears resembled Bam Bam Bigelow, says he will arm wrestle me for the difference. So essentially if he wins, we take his final number. If I win, he pays ours. The mediator, who is a character, says it's crazy, but I should just do it. Then my client jumps in and says he wants to see this too, and he doesn't care about the money. Now I'm 6'0" and 185 pounds, so I was going to have a severe weight disadvantage, but I have always been weirdly good at arm wrestling. So I say, fuck it, tell him it's on if he's serious. Mediator leaves, I put on some DMX and start bouncing around a bit to get worked up like a fighter about to enter a ring point. Go into the room. We agree we are doing this, shake hands and get set up. The mediator is bouncing off the walls, and we have my client and 2 other attorneys watching. Mediator says go, and I just lock my arm and absorb this guy's initial push, then feel his arm give slightly when he realizes he isn't moving me, and then I just go full force and had him down so fast my associate initially though I lost. We shook hands again and went back to our caucus room, and my client was ecstatic that I not only did that for him, but won, and the mediator came in still giddy saying it was the craziest thing he's seen in his career as a mediator. He then said the guy is red-faced and frantically texting because he thinks he didn't have authority to pay that much and did not contemplate actually losing. However, sure enough and true to his word, minutes later we had the signed agreement. Then we went out for some drinks to celebrate, and within a day it was legend in my office. Not a lawyer, but I was sued by some middle-aged lady and her ambulance chasing sleazerbag lawyer after a minor traffic collision. She claimed that the accident caused her so much back pain that it completely ruined her life. Our case depended heavily on one major fact. She had been visiting a chiropractor for 8 years prior to the accident. Her attorney brought in her chiropractor. This guy was such a douche it was actually painful. He was in his mid-40s and came to court dressed in a button-down shirt with the top buttons unbuttoned to show off some chest hair. He started off so cocky. As her attorney questioned him, it was obvious he was being buttered up for jury. Starts talking about how he moved to North Carolina for a girl he fell in love with, how he loved helping people, all this bullshit. He had an incredibly smug, arrogant demeanor, leaning back on the jury stand, cracking jokes, etc. Her attorney asked him if he had any financial stake in the outcome of the case. He said no. Her attorney asked him why he saw the plaintiff for 8 years prior to the accident. His explanation: she initially brought her daughter in to see me. I suggested her coming in for maintenance. She suffered no pain prior to me seeing her. Everything I saw her for was maintenance and preventative care. I thought my case was screwed. Our primary argument was completely dismantled in front of us. Or so I thought. My attorney, who was appointed to me by GCO, got his turn to question him. For the rest of this post, R equals my attorney and C equals the sheet bag chirp pointer. How long have you been practicing? C. Over 15 years. Your license is up to date. C. Yes sir. Are your records reliable and accurate? C. Yes, they are pointer. You said prior to the accident. Plaintiff was never treated for lower back pain. Correct. C. Correct. She was just there for maintenance. Pointer. I have a copy of her medical records. Can you please verify that these are her records? Get verified. A. Can you please turn to her record for the 12th of May 2016. This is the last time she saw you before the accident. What does that say in her treatment summary? C. Patient was treated for lower back pain. That must be a mistake. Our records must be incorrect. Pointer. So you're saying that the record for that date is unreliable? C. Yes, but just that one. It's a mistake. Pointer. Okay, please turn to the page before that. Date's the 12th of March 2016. What does that say? C. It says the exact same thing. I don't know why. Pointer. So is that record unreliable too? C. Yes, I don't know why it says that. It's saying the treatment we gave her after the accident. Pointer. Can you please turn to the date before that? After about 4 more pages, it was blatantly obvious that this guy's entire pre-accident records for her showed her receiving treatment for low back pain. So what you're telling me, then, is that every single record of yours before the accident is unreliable? C. Yes, because of a computer glitch. Pointer. Are the records post-accident reliable? C. Yes, they should be at this point. This dude's whole cocky demeanor was gone. He was shifting around nervously, fidgeting, no longer smoking, no longer speaking all smoothly, and was chugging water like we were running out of it. My attorney started going in for the killer on the first visit after the accident. Can you please turn to that page? It says that plaintiff suffered an accident and had severe trauma to the lumbar spine and would need additional treatment. It says the trauma was clearly caused by the accident. Is this record accurate? C. Yes sir, Your Honor. I would like to submit evidence. My attorney then brought out a single sheet of paper inside a protector. This is a copy of the medical record I received from your office a year ago when I requested the record. Look at it next to the one you submitted for evidence in the case. Notice a difference. The original copy didn't say anything about the accident. In fact, it said the same exact thing that all of the other copies said. This motherfucker went back and changed his records without realizing that my attorney had already seen the initial copy of it. At this point, this guy looked like he wanted to die. His face was red. He was stuttering. It was hilarious. It ended with my attorney asking him if any of his records are reliable. He was backed into a corner and had to say no. He looked so defeated when he said it. The final bit of dialogue was the best. Pointer. Is it true that you have a lien on the verdict of the case? Before he could answer, plaintiff's attorney objected. But the jury heard the question and saw the way the guy reacted. Pointer. Do you have any financial stake in the outcome of this case? C. I am not aware of our financial arrangements with plaintiff. Pointer. No further questions. I've never seen a man more humiliated in his life. It was like 25 minutes of this guy wishing he was dead. I ended up winning the case. Lady tries to sue me for $500,000 in the most bullshit frivolous lawsuit ever, and she walked away with $0 thanks to her dumbass chiropractor. I'm not a lawyer, but I shut down the courtroom with this one. So I was a witness for the state in prosecuting a DUI case. In this case I was a medic that did a blood draw, and I was to testify about why I did or did not recall the defendant was intoxicated at the time I found him in police custody. I didn't recall a whole lot about the specifics beyond what I wrote in my chart, but I knew for a fact I recalled him being intoxicated. The defense pressed me on why I thought he was drunk. The details I remembered, I had to do multiple sticks because he wouldn't sit still. He was an impatient punk making snide remarks. The defense kept pressing me why I thought he was drunk, though that's not enough. I talked about how I probably see more drunk people than sober people, how many blood draws I do, the signs and symptoms I'm trained to observe in alcohol intoxication, how this is backed up by often learning their back at the ear, so I can correlate behavior with approximate levels of drunkenness. But none of that was good enough. Did I smell alcohol on him? I don't recall that specifically right now one way or another. Did I give him breathalyzer? No, I did not. Did he admit he was drinking? Not to me. So why then can you sit there in good faith and tell the jury you're so confident you remember he was intoxicated when you clearly have no memory of such a thing? And I replied with all honesty, if you really must know. After all that, I went back to the ambulance, looked at my partner and said, man, that guy was a drunk as hole. So I remember at the time being convinced he was both of those things. The defense seemed rather taken aback and had no further questions. I was ushered out of a very quiet courtroom save for a few snickers from the jury. Not a lawyer, I was on the stand as a detective in a case where a teen had made an allegation that she had been to visit a male friend she had a crush on, and while hanging out at his house, she was sexually assaulted by the crush's uncle, 22-year, and a couple of the crush's friends. Crush didn't participate, but also didn't do anything. He was same age as the victim, 14ish, and I think the other two alleged perpetrators were around 15. So as soon as we start investigating we find out that the 22-year was a registered sex offender because he'd molested his own sister several years earlier too, registered as residing at a different address, but living at the incident address 3, which is within 800 yards of a church, daycare and a school. So he'd already gone back to jail on those. Months later we get the DNA results from her rap kid 22-year's DNA, no one else's. She nor the crush never identified the two teen alleged perps, and I was never clear that they really existed, or if they did exist, but hadn't done anything. But the 22-year had unequivocally had contact with the victim, so we brought charges on him. Probable cause hearing. I'm there testifying. Victim is not, did not have to be. Defense attorney hammering me about framing his client and not doing enough to find and ID the other two alleged perpetrators, implying that perp was innocent under the SODI, some other dude done it. Defense point, he kept coming at me a couple of different ways, and I was patient for a while, but finally lost patience and snapped that it didn't matter about other possible perpetrators when we found his 22-year-old's DNA in a 14-year-old's vagina. One of those everything stops for a second moments, and I was a little horrified because I'd always done really well in testifying and never lost my temper, and in training they drill you about that. Defense at he kind of froze in his tracks and popped his eyes at me and then looked at the judge. Prosecutor put his hand over his mouth. He told me later he almost cracked up, but I thought it was because I had blown it. Judge sternly told me that was enough and said I could step down. But he found probable cause. Guy pled out and went to prison for 10 years after he had served 18 months after the incident for the sex offender registry offenses. I mostly worked fraud cases, but occasionally caught a serious person's case like this when I happened to be on call. One of the ones it gave me great satisfaction to occasionally look up on the doc inmate database and see that they were still in prison. Not a lawyer, just AVG Joe fighting a speeding ticket. Was following a buddy to a CA ski resort. We were pretty high in elevation, and it was snowing really hard, going super slow. We drive past all the chain control signs that are turned and currently showing that there is no chain control right now, and I look down and tell my wife how slow my buddy was going compared to normal, like under 25 miles per hour. We are coming up to the chain control stop and slowing down, and a cop coming from the other direction flips his lights on and points at me to pull over. At this point I'm stopped in the line. Cop turns around and flips on his PA and tells me to pull over. I do. He comes up to the window and tells me I was doing 55 miles per hour in a 25 miles per hour chain control zone. My mouth drops open and I ask him if he's serious. I point to the chain control sign that we hadn't gone through yet and was actually closing traffic due to avalanches ahead. He says yes, he's serious and it is 25 miles per hour. I turn around and point to the sign behind us that says chain control is not on. At this point he is not listening to reason and I'm furious. He gives me a ticket and I tell him I'll see him in court. On the way down the mountain I take pictures of all the chain control signs, get evidence from Courtrooms, and take a day off to go up to the courthouse. Cop speaks first saying he was wrong about the chain control, but then adds that he still thinks the ticket should be enforced because in his opinion I was driving unsafely. Again I'm pretty pissed off, and when the judge asks me I say this, I don't know what the officer clocked doing 55. It absolutely was not me. Maybe he picked up the snow on his radar, but I hadn't topped 25 miles per hour for the last 10 miles. and as far as his opinion goes, he's probably 10 years younger than me. I grew up driving in northern Wisconsin and the upper peninsula of Michigan, where there is snow for 6 months of the year, so I in all likelihood have a more experience and a better sense of what is safe or not safe when it comes to driving conditions. His cop buddies bust out laughing in the back of the courtroom and the judge dismisses the ticket. Happened 20 years ago and still brings a smile to my face when I think about it. I will try to make short. One of many accusations against my client was that he was privately investigating a federal agent because by the time he got arrested the police found a report on a cell phone number in his house. He had hired a private investigator to research this number, personal business, but it had nothing to do with federal agent, and, for some reason, the police and the prosecutor thought it belonged to the Fed named X. We produced a lot to show that the referred number wasn't owned by any federal agent, including providing answers from the telephone agency that said that the number was from who we said it was, and not the Fed. The judge still didn't believe, and the prosecutor kept pushing it. Then, after months, I got in contact with the owner of the phone and tried to make him testify, but the judge denied it. The Fed was going to testify, though, and here comes the moment. He said that he felt terrified that my client was investigating him etc. Cop stuff, trying to make my client look worse, but when I crossed him, I simply asked, "Can you please read the number on my cell phone?" It was the number under discussion. He read it. I dialed the number. His cell phone didn't ring, but the correct guy does. I brought him to the courtroom. I said nothing more, and my client got acquitted of that accusation at least. Obs, sorry for the bad English, and maybe it is a little confusing, but it is hard to explain in another language, especially because process rules are so different. Not a lawyer, but I had my ex in court to get a no contact / restraining order. She'd been harassing me online and contacting everyone she possibly could to try to hurt my reputation and perhaps bring me bodily harm. I'm normally very disorganized, and she mentally abused me when we were together. She was very oppressive, so we both thought I was a worthless idiot at the time. When I left, I gained some self-worth and got myself together. I went to therapy and got the right medication. So when we got to court, I had printouts of the texts and screenshots in a thick folder, some conversations she apparently didn't even think I had. I handed it over as evidence, and the judge had her look it over first. Flipping through it, her eyes widened with shock and embarrassment, probably hoping they weren't going to be shown to the rest of court or read aloud, because her new girlfriend was with her. They brought to light what a monster she was, so I doubt she wanted her to see them. The judge asked, "You wrote these? Do you verify this evidence?" She set the folder back on the table and looked down in shame. "Yes, Your Honor." He read all of them with a disgusted look on his face and granted my restraining order. He asked if there were any questions after that, and she went on about how she just wanted all this drama to finally end and get past it. The judge literally rolled his eyes and dismissed me and told her to wait 30 minutes before also leaving. Not sure if this fits the prompt, but fuck, it was so satisfying to finally see this person who treated me like she'd get what she deserved. She apparently contacted my aunt months later and told her that she had a restraining order on me. Some people can never admit to anyone, including themselves, that they're actually horrible toxic human beings. I have two quick stories. I consider them bad, as is because they came against large firms who brought 3 or more attorneys to the hearing against just me. The first was a motion for criminal contempt against my client in a civil case. All the lawyers come in, about 5 of them, because they were 2 plaintiffs. They bring with them a bunch of witnesses. I'll let them start by call their first witness. As soon as the witness is sworn in, I move for denial of their motion. Under my state's rules, all criminal proceedings must be recorded by a court reporter, even in civil cases. In criminal cases, the state provides the reported. In civil, you must provide your own. One of my adversaries knew this. Judge granted my motion to deny, and we got up and walked out. They were pissed. My second was a hearing for which I had to bring either witnesses or witness affidavits. I did neither. This time, I was unaware of the rule. Opposing counsel raised my defective motion and provides the judge case law. I'm thinking I'm dead and I just committed malpractice. I quickly read the case law and see the rule also says, or the unsworn testimony of the lawyer. So my quick response is I tell the judge I'm ready to be sworn in to testify as a witness. Judge agrees. They object. They had two choices, I testify or we schedule, which at that point I correct the deficient motion and attach affidavits. They decide to move forward. 3 lawyers grill me for over an hour. Motion granted on my side. I win. Walked out smiling because I kicked their ass and they couldn't break me in testimony. Again, they were pissed. Knowing when to object, but choosing not to is more important than simply knowing when to object. Especially if it means opposing counsel wastes their time, focuses on the wrong legal theory, or contradicts themselves. I had a divorce trial in April, where I could have objected to my opposing counsel's expert witness, based on his qualifications, but I saw his expert report first. The expert report is the basis for an expert's testimony. Opposing counsel and I stipulated to both experts being allowed in under the auspices of saving time. His expert based a large portion of his report on the concept that self-driving cars would quickly make auto body shops obsolete, and thus a family-owned shop should have zero market growth and never be worth more than $12K estimate he gave. On cross I hounded him about self-driving cars. The judge's findings of fact and conclusions of law included in the divorce decree had a separate paragraph outlining why the judge did not choose to incorporate any of the opposing counsel's expert testimony or report in determining the value of the shop. Specifically because the weird lengthy tangent spent on self-driving cars causing zero market growth. Edit. I guess I should specify that for me. It was an I rest my case moment, because the main asset being argued over at trial was the value of the auto body shop. Our expert had it valued at roughly $320,000, while their expert had it valued at roughly $80,000. $12K for the business and intangibles and $68K for the real property. This was back when I was law school, so it was more theoretical than anything else. But I was in an advanced litigation skills workshop that was held one evening a week in a small classroom inside of our law library. Now, there was for most of us a several-hour break between our last traditional class of the day and this workshop, so a group of us would often go to the on-campus bar for some drinks before this class. This particular evening, we had actually had a free beer event, which occurred once a month for the law students, and you wonder, while lawyers have substance abuse issues, so we were a little extra tipsy going into this class. The exercise for the evening was sentencing arguments, with students assigned to argue each side of whether or not a convicted murderer would be a safety concern as to life in prison as opposed to receiving the death penalty. The big issue was something to do with the convict's PTSD. I was assigned to the death penalty side. To complicate things, an actual professional psychologist was brought in to play the witness, who was testifying as to the convict's mental state and why he would be fine in prison. Being assigned to the death penalty side, my job was to cross-examine her after the other side finished. I walked the witness through the various things that could trigger someone with PTSD, and many of my classmates were kind of zoned out because several other teams had already gone through the motions on this issue before I took my turn. One of my friends even had her eyes closed, just listening to my questions, because we had practiced it earlier in the day and she already knew what was coming. Or so she thought. Thanks to a few too many free beers, and looking around the room, the little red guy on my shoulder got an idea. I was standing at the front of the room, behind a mini podium made of metal that was placed on top of the table. As a final line of questioning, I established that sudden, loud sounds could startle and set off someone with PTSD. The psychologist admitted that this was certainly possible, but that it would be unlikely for that to occur in a prison environment. This was exactly the response I needed. I waited a moment, then slammed my palm down onto this hollow metal podium. We were in a small room, in a silent library, with half the class distracted, tired, or buzzed/drunk. And my hands aren't the biggest, but I do have big meaty palms and a background as a competitive volleyball player. So when I slapped my hand down, it was like an explosion in that small space. I had 2 professors in the class, one of whom yelled "holy shit." 2 other people almost fell out of their chairs. My friend, with her eyes closed, by her own admission, almost peed her pants. Once the commotion died down, I just looked at the witness and asked, "That sounds a lot like a prison cell door closing, does it not?" She had no choice but to agree with me. I'm shocked I was able to keep a straight face. As soon as the critique section of that presentation was over, while shocking, they found it incredibly effective. I excused myself to go to the bathroom, just so that I could laugh at the ridiculousness of what just happened. Now about 10 years ago, I, 25 meters, was driving home from a bar in New York City. I will and did admit to having a few drinks, but I wasn't over the legal alcohol limit. Apparently, the West Side Highway was shut down for, coincidentally to the story, a drunk driving crash. The only problem was that there was nothing blocking the entrance to the highway. That I got on point cut to me driving on an empty highway. Inconceivable in New York City, and I've got an eerie feeling. All of a sudden I come across the accident scene. There were flashing lights everywhere, several police cars and ambulances. As I slow down, an officer basically sprints over to my car and orders me out. He breathalyzes me after I tell him that I had a couple of drinks. The reading isn't high enough to arrest me, but instead he is yelling and screaming at me for entering a closed highway. He leaves me in my car for an hour, then comes back and hands me several tickets for basically the same thing. Failure to adhere to a traffic signal, illegal entry to a closed roadway, etc. So I go to the court date and the cop is amped up and ready to crush me. He goes through his spiel to the judge, and unlike some cops who read their notes and might not seriously remember the incident, this guy was waiting for this. So now it's my turn to speak, and I look at the judge and very calmly say, almost all traffic infraction are committed to speed up the perpetrator's travel, whether it is speeding or running a stop sign, etc. Why would I enter a closed highway so that I could be predictably delayed by over an hour while waiting for an accident to be cleared up? How would this infraction help me? And if it wouldn't benefit me in any way, why would I knowingly commit it? All tickets dismissed and I floated out of the courtroom. Not a lawyer, but this is a legendary court case in the region where I'm from. It involves one of the German internet giants, who is a bit of a slaveholder as far as worker benefits and compensation goes. They went through people so fast at a time that they couldn't find any more employees in our region except for the desperate, dumb, or those with a high resistance to suffering. One local lady had worked 4 years in a call center of them and eventually quit. As is customary, her resignation letter not only went to ours, but also to the company's union office, where it was allegedly framed and put up on the wall, and copies of it were passed around as meme as well. The resignation letter of that lady basically said, "My health and sanity no longer permit me to follow the explicit orders of my superiors, to lie to our clients and to cheat them out of their money." Eventually, the big boss got wind of the contents of the letter and had corporate law sue the lady for damages. The case went to the local district court and the defendant of that lady must have had a field day. The corporate lawyer read the accusation, which stated that her resignation letter in essence was betrayal of trade secrets and she should be fined for that. And they had no other evidence than the resignation letter, which the union representatives had passed around, not the lady herself. Before the defending lawyer even had a chance to say something, the judge interjected and addressed the CEO, who was attending personally, and castigated him for wasting the court's time. Because the indictment itself contains the admission of guilt on behalf of the prosecuting party. Case dismissed. Arnold, and neither is my friend, but he was pro se, representing himself in circuit court on an appeal for a harassment conviction that never should have happened. In this state there are multiple levels of harassment in the statute, with like A being a minor misdemeanor basically, B being a little more serious, and C being a felony. A police officer who did not do any kind of investigation at all after the complaint might have chosen A or B to put on the arrest warrant, which also serves as the charging instrument / document in this state. An officer who actually did an investigation wouldn't have charged at all, but that obviously didn't happen. This officer puts C on the warrant. Friend gets arrested, posts bail, tries to defend himself initially, and get convicted in magistrate court of B. At this point he hadn't realized C was on the warrant, because a magistrate in this state can only sit on cases that have stakes of no more than $500 or 30 days in jail, and C harassment was thousands of dollars and up to a year or two in jail, maximum. Magistrate imposes $500 fine, which wow, that's the maximum he can do, and no jail time. Friend hires a lawyer for appeals at the magistrate level and I forget the details, but basically the lawyer is not great and gets shut down. While arguing a motion point, friend appeals pro se to the circuit court equivalent, the higher court that would hear a full appeal, and while in court arguing a motion for dismissal, I think, points out that the charging document said C harassment. The charge was never amended, and the magistrate went ahead anyway on a charge he had no business hearing. The magistrate's court recorded a conviction for B in their paperwork. Case dismissed, conviction overturned. I used to practice family law, specifically taking domestic violence cases. I represented mom, who was the best. She moved heaven and earth for her 2 kids, worked full time, and went to school full time. Dad, meanwhile, was a lazy, aggressive asshole who hadn't seen their kid in 3 years. She stopped having him visit because he got mad and refused to return the child. He represented himself and would try and make crazy demands, like asking for sole custody 1 minute, but agreeing to give up custody if he didn't have to pay child support the next. Can't do that in my state. Anyway, this goes to trial. I'm not a mean person, but I see he has outstanding warrants and a suspension on his license because of traffic tickets. Personally, I think those are bullshit, but I needed to show that transporting the kid would be a problem. I asked who will be driving the child because his license is suspended. He said he would, and that I'm a liar. I asked twice more if he was sure he had a valid license and showed him a driving record. He said again that I'm lying in court and trying to give the court funny documents. I then presented a copy of the register of actions to the court. The judge called a brief recess and said, "Ms. Nerda Queen, could you take a step back?" I thought he was handling another matter, but he had Dad arrested for the outstanding warrants. He then ruled in my favor for everything. Not an attorney, but I used to have to testify in court for the mortgage servicing company I worked for. I had to go out to Orange County, CA, because while trying to foreclose on a home, the title to the property was not clear. The owners of the house were real estate agents and husband and wife. Sometime after the housing market started to collapse, they filed paperwork that basically said they no longer owed any money on any house they owned. They owned several. I testified that the document was not legitimate because there was no signatures from any financial institution, and that I had never even seen such a document. The doc was multiple pages and looked legit, but the only signatures anywhere were the husband and wife's. When the husband was testifying, he basically said they didn't file this document and had no idea where it came from or why it had their signatures on it, basically admitting the only document clouding title was this fake one. They lost and foreclosure could proceed. Pointed then got super awkward because they started crying, and this was the last case of the day. I gather my things to leave and head towards the elevator, but there is husband and wife crying waiting for the elevator. I took the stairs and was probably on the 14th floor. Let me also add that yes, financial institutions in this country are shady as fuck, and it's why I have switched fields. But this family basically stopped making payments because of this fraudulent document, and it had been years since they made one. The foreclosure crisis is 1/3 people who had a minor hardship, 1/3 people who should never have taken out a loan and will always be bad at financial things, and 1/3 people like this trying to game the system. Not a lawyer, but reading the motions filed in the most recent Harmony Gold vs. Piranha Games Incorporated lawsuit was pretty wild. TLDR of the history is that PGI has certain robots in MechWarrior Online that are based on old Macros designs. Harmony Gold, owners of Robotech, the 80s localization of Macros, claimed that PGI infringed on their copyrights. They even filed production sketches of specific robots as the exhibits they were suing over. PGI's counsel did their homework. They motioned for dismissal on the grounds that Harmony Gold did not own the copyrights to the robots. filed in the exhibits that they merely had an exclusive license to internationally distribute products using those designs, and thus they have no standing to bring suit. The big fuck you moment came when PGI's counsel filed several exhibits with their motion for dismissal. They were production sketches of the robots in dispute that were the exact same as what HG had filed, except that these included the original copyright mark in the corner for the original Japanese production company, a mark mysteriously absent from Harmony Gold's filing. PGI's counsel had scanned the images directly from a Japanese Macros anniversary art book. The judge was pissed. There was also a bunch of other crazy stuff that happened, but that right there was the point of no return. In the end, everyone ended up settling out in exchange for HG willfully filing a motion to dismiss with prejudice. Not a lawyer, but I had to represent myself for a traffic violation. Basically, there's this intersection right before an on-ramp onto a major freeway near where I was going to school. At 12 noon, when my class finished, I would have to drive onto that on-ramp to go home. Anyway, one day I was in my Civic and was right behind this large shipping truck. I could see the traffic light was green, but couldn't see it anymore the closer I got to the truck, so I relied on the vehicle in front of me to continue moving. When we reached the intersection, the truck moved forward and stopped onto the crosswalk lines. This truck could not move, and I was stuck behind it with no way to get around it, since all the cars behind me were going around me onto the next lane until the light turned red. Next thing you know, this cop pulls behind me with its light on, and I get a ticket. Weeks passed, and I finally decide to go to court to try to explain myself. Since I waited for the last minute to make an appointment, I was one of the last to be seen by the judge. Defendant after defendant went up to plead their cases, and time after time, each person caught speeding or running red lights were found guilty. This judge had no compassion, even if the people who ran red lights entered the intersection while the light was yellow. Anyway, it was my turn to be seen, and the judge asked the cop what had happened. The cop said that I entered the intersection on a yellow light and did not make any attempt to move out of the intersection to keep from blocking traffic. Slam dunk case, right? Well, he smugly stood there and figured he won the case, since the judge found everyone else guilty if they entered the intersection on a yellow light. The judge then turns to me, asked me for my story. I told the judge that I was behind a big truck and that when I entered the intersection, the light was green, and I can prove this because when the truck stopped me short of clearing the intersection, all cars behind me began going around me for some time. In fact, cars were back to back and there was no way for me to cut in to go around the truck I was behind. I told the judge that if the light had turned red, why didn't the cop go after the ones who ran the red light? I told him it was because I entered the intersection when the light was green and then it turned yellow, allowing several cars to pass me. If I had moved out, I would have caused an accident. The judge paused for a few seconds and stared at the cop. He then turned to me and said I had a very compelling argument, and then said, "I find for the defendant. Case dismissed." I then thanked the judge and decided to turn to look at the cop who had his head down. I then turned to look behind him where he had been sitting with about 10 other cops. To my delight, I saw them all chuckling at him. I walked out of there with my head held high. The dude shouldn't have lied. Typical. I'm not a lawyer, but I applied to live at some apartment buildings owned by a massive residential property company. I was approved, but when my background check came back with one arrest from when I was 18 years old, no conviction, they called and said my approval was revoked, yada yada. I escalated it to some guy in their corporate office. He gives me the whole "I'm on your side, it's just policy, I'm doing all that I can" thing. He asked for the certified disposition for the case. No luck. So I sent this really long email: "Hello, corporate guy. I finally received the certified disposition in the mail, and I have attached it to this email. I have also submitted a request for the report from the screening agency, provided in the letter you sent me via email. As you will see in the disposition of the case, I entered a plea of nolo contendere and received a withhold of adjudication. I entered this plea in order to avoid taking the case to trial and any chance being convicted. I was not convicted for this charge, and it is the only time I have ever been in trouble. The reporting agency informed me that massive residential property company denies application for any felony or deferred felony drug charge with no time limit. And although I understand that it would be completely unintentional on massive residential property companies' part, I do have questions regarding the discriminatory nature of these conditions. I understand that the intention is to keep your properties free of drug use, and as someone whose life was nearly taken by a brief addiction at 18, I truly appreciate that endeavor. I do not want to live where drugs are, and I do not want people in active addiction living next door to me. However, I do believe there is a less discriminatory way to go about this that takes a more individualized approach to the screening process. The HUD's guidance on application of Fair Housing Act standards to the use of criminal records by providers of housing and real estate related transactions can be found at https://www.hud.gov/sites/. I have also attached a copy to this email, and I would like to point out a couple of things included in it that better express my concern. Under the section titled Exclusions because of prior arrest, it states that a housing provider with a policy or practice of excluding individuals because of one or more prior arrests without any conviction cannot satisfy its burden of showing that such policy or practice is necessary to achieve a substantial legitimate non-discriminatory interest. 25 As the Supreme Court has recognized, the mere fact that a man has been arrested has very little, if any, probative value in showing that he has engaged in any misconduct. An arrest shows nothing more than that someone probably suspected the person apprehended of an offense. 26. Because arrest records do not constitute proof of past unlawful conduct and are often incomplete, for instance, by failing to indicate whether the individual was prosecuted, convicted, or acquitted. 27. The fact of an arrest is not a reliable basis upon which to assess the potential risk to resident safety or property posed by a particular individual. For that reason, a housing provider who denies housing to persons on the basis of arrests not resulting in conviction cannot prove that the exclusion actually assists in protecting resident safety and/or property. I understand that my case is sort of in between just an arrest and conviction, but even in the section titled Exclusions because of prior conviction, it states that a housing provider with a more tailored policy or practice that excludes individuals with only certain types of convictions must still prove that its policy is necessary to serve a substantial legitimate non-discriminatory interest. To do this, a housing provider must show that its policy accurately distinguishes between criminal conduct that indicates a demonstrable risk to resident safety and/or property and criminal conduct that does not. 32. A policy or practice that fails to take into account the nature and severity of an individual's conviction is unlikely to satisfy this standard. 33. Similarly, a policy or practice that does not consider the amount of time that has passed since the criminal conduct occurred is unlikely to satisfy this standard, especially in light of criminological research showing that over time, the likelihood that a person with a prior criminal record will engage in additional criminal conduct decreases until it approximates the likelihood that a person with no criminal history will commit an offense. 34. Accordingly, a policy or practice that fails to consider the nature, severity, and recency of criminal conduct is unlikely to be proven necessary to serve a substantial legitimate non-discriminatory interest of the provider. The determination of whether any particular criminal history-based restriction on housing satisfies Step 2 of the discriminatory effects standard must be made on a case-by-case basis. 35. Further, and with regard to addiction itself, the article found at https://www.narlo.com/ states that while addiction itself is protected as a disability, illegal drug activity isn't. The FHA doesn't bar discrimination against tenants who are current illegal drug abusers and tenants who have been convicted of the illegal manufacture or distribution of drugs. The FHA specifically accepts current illegal use of or addiction to a controlled substance from its protection. 42 U.S. Code 3602 H. Also, Federal regulations clarify that, while the ban on disability-based discrimination includes any mental or psychological disorder, it doesn't include addiction caused by current illegal use of a controlled substance. 24 CFR 100.201. 2. Since I do not have any convictions, let alone for manufacture or distribution, and b. do not currently, and have not in the past 4 years participated in the use of illegal drugs, I feel that this information is relevant. I know that this is a really long email, and I want you to know that I really appreciate everything you've done to help me try and figure all of this out. I just wanted to include all of this information so that when you consult with your company's legal team regarding my application/denial, you can include my concerns regarding the policy as well. Thank you again. Me. I got a call from the office manager the next day saying I was approved and good to go. Felt good. We did a mock trial when I was in high school. We were reading about the Salem witch trials. I was on the prosecution. We had a couple pieces of evidence that we had cooked up. The defense had rested pretty heavily on a witness who that had repeated over and over that they were a God-fearing good Puritan man. That was their biggest demonstration of character. This witness claimed that he was with the accused at the time when we had put the accused committing the crime and that she was not at the scene. The trial was mostly over, but the defense had a chance to re-examine anyone we had cross-examined. Cue defense calling their main witness. Defense asked leading questions to reiterate the character of the witness. In the middle of one of these questions, defense attorney mistakenly says, "You are a good Puritan man. You attend church annually, don't you?" Witness says, "Yes, I do attend church annually." At this point I quietly raise my hand and wait to be recognized while defense concludes their re-examination of the witness. When the judge calls on me, I grin and point out that the witness said he attended church annually. I ask the court what kind of good Puritan would attend church once per year. Defense half realizing their mistake and trying to argue that annually means all year. Judge had none of it. With that, the witness's credibility was destroyed, so the defense had nothing else against our evidence. Defendant was found guilty and promptly hanged. Technically my husband's story, but it's r/us credit, so I'm going for it. My husband's ex wanted to move across the country. They were informally doing 50/50 custody every other week. She attempted to DIY a move order. My husband got a lawyer who put together a parenting plan that reflected the reality of what they were doing at the time, 50/50. In it, he checked the box listing my husband as the custodial parent. When they got before the judge, the ex gave over all the paperwork. She had filed a mishmash of documents, some of which were related to a move, some were completely unrelated. The judge was confused about what the hell was going on. Ex said, "I just want to move to state." So my husband's lawyer basically said that we've got a parenting plan here that we'd like to discuss, and then he'd be happy to discuss the move. The judge latched onto the only paperwork in the room that made any sense and asked the ex if she had any objections to the parenting plan. She didn't and signed it right there in the courtroom without reading it. My husband's lawyer then stated, "Since my client is a custodial parent, ex does not have the standing to request the move order." The judge looked at the document, agreed, and then denied the move order. My stepdaughter's mom still has no idea what the fuck happened that day or how she managed to screw herself over. If your opponent has a lawyer, you cannot afford not to have one. This is a story from the dinner table that my dad detailed when he was a public defense attorney. It's one of my favorite stories, even though he was defending scumbags. This was probably back in 2002. His clients had been followed by police in unmarked cars for several miles. The police wanted to pull the guys over because they knew they were big drug dealers, but they had no probable cause. They kept looking for ways to get them. They followed them way out into the country, down a few roads, and eventually the drug dealers failed to signal when making a turn. The officers pulled them over, started talking to them, then smelled weed. Now they had the probable cause, searched the vehicle, and found 20 pounds of marijuana and 1 pound of meth. Arrested them. It goes to court. My dad has done his research and comes in with a very large poster board printout. He then tells the judge that his clients were illegally pulled over. He then reveals on the poster board that the officers had followed the drug dealers onto private property and that they had pulled them over for failing to signal when the laws do not apply on private property. The officers were out of jurisdiction, and every action they took was illegal because they had no legal right nor warrant to perform any searches on private property. The judge asks, where did you get this large map of the property lines and roads? And my dad says, I went to the dot and they gave me the map. Then I went to Kinkus and they printed it out. The judge looks at the DA and says, you knew he had this evidence and still brought it to my court? The DA said yes, and the judge then chewed out the DA for 5 minutes and dismissed the case. The drug dealers walked out free as a kite. The drugs were destroyed, and the local paper wrote an article about the drug bust flopping in court and how the DA and police department had egg on their faces for being idiots. Witnessed an incredible defense attorney cross-examine a police officer for 45 minutes who submitted a ski mask into evidence and said the bank robbery suspect wore it in commission of the robbery. The defense attorney was making him feel comfortable in his recollection of events, then asked that the defendant put on the ski mask. Then he asked the court that the bank CCTV tape be played for the jury. The prosecutor objected. The court overruled the objection. The defendant couldn't put on the ski mask submitted as evidence because it was simply a winter hat. The CCTV footage was run for the jury, and it did show the bank being robbed by a white male not wearing any mask or hat. The defendant was a black male with no previous criminal record. The judge calmly gathered the prosecutor and defense attorney and told the prosecutor he needed to drop the case and save face. The prosecutor angrily asked the case be dismissed and charges dropped, then threw his suit jacket into the gallery. 2 years later, that racist was elected county prosecutor. The defendant went on to move out of my hometown because police constantly harassed him. The attorney was already a mythic character in the Atticus Finch mode and practiced law until he died. He reportedly never drank at a bar or dinner because good cops let him know the higher-ups wanted to get him on a DUI for exposing their sloppy work to the public. That prosecutor then became mayor and was charged with beating his wife in a drunken rage. Long story short, it is easier for a camel to fit through the eye of a needle than good decent people to go up the ladders of power. I wasn't a lawyer at the time. This was a high school mock trial, but it was fun nonetheless. For those unfamiliar, mock trials are like normal trials, but fake. As a result, it doesn't go until arguments are exhausted, but instead each participant is given a time limit and has to make their case within that period, so everyone can go home in a timely fashion. The time limit was 10 minimum for us, but you could go slightly over if needed. In Idaho, we were competing against a local school in a case that centered around an alleged hostile work environment. I was one of 3 attorneys doing direct examination in my team, and my witness, playing the company's CEO, happens to be a close friend of mine, so we were well prepared. At trial, I get through all my questions, passed across, and that's when the fun began. The opposing attorney got through about 6 questions before my friend gave an answer he didn't expect. Rather than simply moving on with his questions or jumping to another line of questions, opposing counsel chose to repeat his question slightly differently, in a way it would have been proper for me to object to with asked and answered. I didn't. Instead I sat there, silently, as this poor faking kid spends his whole time trying and failing to get the specific answer he wants out of my friend. So, after 10 minutes of him restating his 6th question to no effect, I objected. The judge, sick of listening to the same question, said something to the effect of "I would hope so. You spot my plan yet?" Rather than object, the question had been asked and answered already. I simply stated the cross had used their full allotted time and that he shouldn't be allowed to continue. Remember, he was 6 questions into his argument, so all he had gotten in his 10 minutes was my friend's name, age, place of work, job title, and that they had meetings at work. I shouldn't need to tell you none of that is particularly useful for proving a hostile work environment claim, but I did anyways. The opposing counsel looked very confused when he realized what had happened, and the judge, kindly, suggested he move past that question and finish his examination quickly. He moved on, got slightly further into his questions, but not far enough, and eventually had to stop due to time. Still nowhere near where he needed to get to. My score wasn't particularly high. After all, I missed an easy asked and answered objection for 10 minutes, but higher than his, and we won as a result. Good times. Another mock trial story. Me and a different buddy were running late and definitely stole a parking space from someone while attempting to make it inside quicker. Get inside, and the same dude whose parking spot I just stole walks in a minute or two after me. Turns out it was the judge who was presiding over our case that day. We lost that one after the judge awarded bonus points to the other school. It was ostensibly for a very clever argument they made, but I maintain it was because he recognized me and my friend and was unhappy about the parking spot point. So I rested one case with a sneaky trick and got another case ripped because of a parking dispute with the judge. I was doing a competition here in England called the mock bar trial. It's basically a thing where schools choose a team and get given a case. I was chosen as one of the 2 prosecution lawyers. Anyway, we did quite well in this competition and ended up reaching the finals, where you have to redo one of the previous cases. My partner and I had one about someone who had taken a knife into a public area after being in an argument with someone. The first time we did this, I had seen something in the statement of the defendant who I was cross-examining. The statement said that the knife they allegedly took was on the kitchen counter. However, the police report said it was on the table. When I first did this case, the person brushed it off and said that someone else must have moved it, but I still thought it would be a good note to end on and kept it as my final question for this time point. So I started the case with my partner. We examined our witnesses and they cross-examined, and it all seemed to be going well, but neither side was winning outright. So it got to the defendant's turn with me cross-examining, and I did all my questions, probing further into some angles if I needed, and then it got to the final question. I asked it, and it took her by surprise. She panicked and said that she had moved it. This was as much as we needed to get the win over the team. I turned to the judge and did the whole case close spiel. I have to admit it was a great feeling. The entire case had been even and that ended with us getting the win. However, our other team, the defense, got awful scores, so we didn't even get a placement overall. To Quicks 1, I was representing myself in a registration ticket in city court and brought the statutes with me. I worked nearby, so I just went over to argue on the principle that I was right. I tried to argue my point and the judge said, condescendingly, "What do you think, you're a lawyer?" To which I replied, as a matter of fact, I do. The statute allowed me to not renew my inspection until my previous state inspection expires. In New York, the inspection is on the left and my old inspection was on the right side. The parking attendant showed the judge the photo and she said there's nothing she could do. I said, "Judge, I registered my car that day. I had 1 week to get it inspected. Moreover, this statute states I do not need to get it inspected until my other inspection expires." She refused to listen to me, to why I replied, "Judge, there's 2 separate laws that support me." She refused again. The parking attendant, to his credit, said, "This isn't fair," and he's right. I want to withdraw the ticket. He shook my hand and apologized. Second one was my old apartment. They issued a 12.5-month lease, with the total amount due being 12 months of rent. When I moved out, they kept half a month's worth of my deposit, stating I only paid for 12 months instead of 12.5. Several letters later, their counsel calls me to threaten me. I burst out laughing, tell them that I'm an attorney as well. What they are doing is improper under rules of professionalism and their client drafted the mistake, not me. Took them to small claims, got treble damages, triple, and bought a RAL TV with the extra $2,000. Sent a thank you note with a picture of the TV to their attorneys in the apartment. This is kind of the reverse, but I got into a car accident when I was 18 that I consider myself responsible for. I was driving home through a residential area near a school doing the speed limit, but I guess I was slightly too close to the car in front of me. We were coming to a light that was green, and it turned amber. Immediately when it turned amber, not red yet, amber, the crossing guard walks out into the street to cross some kids. The car in front of me stopped short, and in order to not rear-end her, I turned my wheel to the left hard to try and miss her bumper. I wound up clipping her driver's side bumper and had to go to court. On my court date, I had just taken an overpass bus home from Boston. I was visiting my boyfriend at the time. I got off the bus and then went to court. I was exhausted and moving a little slow because I was so tired. I get to court, and before going to the judge, I speak with the adder, who tells me they'll be dropping my charge down to obstructing the flow of traffic, which was slightly more of a fine, but carried no points. Great. Awesome. I'm thrilled. So I finally have my turn to go to the judge and read off my info and ask, so, you are pleading guilty to obstructing the flow of traffic, is that correct? I said yes. He follows up with, please explain how you obstructed the flow of traffic. It was so unexpected, and I was so tired that I was a little stunned for a moment. My exact response was something like I blocked cars going the other direction when I turned my wheel to try and avoid hitting the car in front of me, punctuation included. I'm sure I sounded ridiculous. He accepted the plea and I paid $300. I still laugh about it because it was just so absurd to me at the time, and I'm still surprised that I managed to formulate a response that made sense. My friend is a lawyer. I asked him for his response to this. Apologies for the lack of legal terminology. He changed details to ensure confidentiality and explained it in basic terms. He was defending a client, who we'll call Bill, who was being sued for causing actual bodily harm through negligence. A young guy had been working for Bill and tripped in the storeroom, landing on his shoulder. He rang in sick for several weeks and then complained that he could no longer work due to the injuries sustained and wished to sue for lost earnings. Despite a suggestion from other workers that the guy had purposely been disobeying safety rules when he tripped. Bill offered to pay all medical expenses, but the offer was rejected and a lawsuit was filed. Whilst the guy was giving evidence to the judge, my friend was taking a last-minute look through the doctor's notes and realized he could prove the guy was lying. He asked the guy why his arm was still in a sling several months afterwards, and then asked him to explain how debilitating his injury was. The guy spent several minutes going into great detail as to how his life had been affected. My friend then asked him to describe the nature of the injury and if the medical notes were correct. The guy looked everything over and confirmed that everything was correct. My friend then pointed out to the judge that the guy was right-handed and would have probably used his right arm to break his fall, and the medical notes said the guy had complained of pain in his right arm. However, he was now wearing a sling on his left arm and had continually been using his right arm to drink water and gesticulate whilst talking to the judge. The guy had no answer for it, and the case was dismissed immediately. Not a lawyer, but definitely satisfied. Last year I was on the way to the hospital because my sister had just had her baby when I had to come to a hard stop on the freeway. There was a large strip of tire in the road, the kind that comes off of a semi, and my car was small enough that I was worried it would take my bumper off. Guy behind me, who is in a large work van, does not stop and rear ends me going about 65 or 70 while I'm not in motion. Needless to say, I ended up going over that tire strip anyway and getting the trunk of my car smashed in. I get pulled off to the side and call the police to report the accident. There's enough damage that 3 officers show up. We give the exact same story on the accident report. He's found at fault, and I think, okay, that's sad then. Well, apparently it's not, because 5 whole months later he decided to plead not guilty to the traffic charge, and I'm dragged into court as a witness to the accident. I wasn't in the courtroom for 5 minutes before the state lawyer leans over to the guy and says, you know they can fine you a lot more money than you already owe for this, if they find you guilty anyway, right? He casually mentioned this off the record before court had started. Of course, he decides to change his mind and plead guilty. I think he was banking on me not coming to testify against him, the absolutely dickhead. Copy and pasting a couple of old stories. My first ever civil trial, I was representing the plaintiff who wanted to evict the defendant from her property for non-payment of rent. After presenting my case, the judge asked the defendant to present his evidence. The defendant replied, "Huh." The judge said, "Now is your turn to present your case." The defendant said, "I don't understand." The judge leans over the bench and asks, "Why are you here?" The defendant said, "Oh yeah, right. The defendant then went on a 30-minute tangent about all sorts of things like how he only parks his car so he can see where he is going when he pulls out, because that was taught when he was in the military. I could have objected, but the more he talked, the more the judge disliked him. After 30 minutes the judge finally asked about the rent. The defendant says, "Oh yeah, I'm not trying to debate that I didn't pay it. That's how I won my first civil trial. Point 1 where I was on the losing end. I was a youth prosecutor / defense attorney in teen court. The youth defendant was on trial for assault. I asked him what happened and he said, my friends told me I wouldn't beat up the Easter bunny at the mall, so I did. Only time I truly could not control my laughter in court. One I watched. I was watching a detention hearing in federal court. Only issue is whether the defendant will get to go home until trial. This was an appeal of the court's previous decision that the defendant be held until trial. Things were proceeding mostly as normal. The first 2 witnesses were law enforcement officers who testified regarding the charges and the strength of the evidence, money laundering in the ballpark of $15 million. This guy was basically a low-level Bernie Madoff. The third witness was an FBI agent, which, needless to say, is not normal at a detention hearing. The FBI agent testified that some other attorney, not the one representing the defendant at the hearing, had been taking letters from the defendant and sending them to different people for the defendant. Those letters were contracts to have the prosecuting attorney killed. Then, the FBI agent played jailhouse phone recordings where the guy was trying to recruit someone to have the prosecutor killed. The representing attorney withdrew, and the defendant was not released pending trial. But there's some funny stories here, so I'll throw in one more for the people like me that keep reading through comments. Kinda funny but fact. Cops. I went to court with 3 friends when I was 11 for riding a bike in a park. Friends were 12 and 14. I'm white and both friends black. For context, we sit in court for a while until the judge calls us up. He asks us what happened, then literally laughs and dismisses the case without any follow-up questions. That part is funny, but the actual story is faked up considering it happened in the 2000s in a large diverse city. Essentially, we rode to a city park on bikes and scooters with my mother. There was a festival going on with cops standing at the entrance from the park side we rode in on. They said you couldn't bring bikes in, but they've seen tons of people walking with bikes, so obviously the other entrance is letting them in. We go around to the entrance that's no longer in the park, but entering from the city. An old fat white cop on a motorcycle is guarding that entrance and says no, you can't come in. We point out people walking their bikes right behind him, and he says well I didn't see them enter, so they're fine. All white people for context again. We return to the other side, so we can leave, in the park, but not in the festival area. My mom decides to walk through the festival to meet us while we go around. As we're standing next to my bike and their scooters, waiting, the motorcycle cop rides through the festival to come yell at us for breaking the law, riding bikes / scooters in the festival grounds. This cop had talked to my mom, and I grew up watching Law and Order with my parents, so I said I didn't want to talk until my mom caught up to us. Dude proceeds to faking yell at us for being terrible, bringing all of us to tears, and not answering anything we ask until my mom catches up 2 minutes later. She's pissed. He refuses to give his badge number and speeds off through the festival on a motorcycle that is apparently too dangerous for bikes and scooters to be in. 2 weeks later we all get a court summon for not paying the ticket when we never got one. Never got that cop's badge number, and racist cunt never showed up in court. Which is why as a white guy I haven't trusted the cops since I was a kid. There's rarely moments like this, in my experience, because there's rarely surprises if everything has been thoroughly prepared and you reached out to witnesses to prepare them. However, my favorite cases are when I have someone dead to rights and they're foolish enough to go to trial. I'll share a couple of stories first. This was a case where a woman was very clearly lying about her ongoing relationship with a guy who was abusing her children. The man was in jail at the time of the hearing. I sought out the jail calls between the two because the woman was continually representing she had nothing to do with him. The abuser was calling from the jail using other inmates' PIN numbers in an attempt to mask his identity. During one of the jail calls where the woman was claiming love for him and preparing to bond him out and have him return home, she mentions that she's worried that someone could be listening in. The abuser called her a faking idiot for thinking that. I'm sure you could imagine my facial expression as I was hearing this anyway. I pass these calls in discovery to the defense, and they still insist on going forward and call the woman to testify. I softly walk her into a position where she had to either lie or tell the truth. She opted for the lie. I had the tapes ready to play because I anticipated all of this. The court had the pleasure of hearing the woman, in her own words, perjure herself. She lost custody of the children to an estranged father soon after. That's one example of several where I've played jail calls directly contradicting someone. I've had other cases where I received huge reams of incriminating text/app messages and had a field day walking the witness down the path of lies they were caught in. It really doesn't get much better than that. I've also had a few cases where the witness essentially got extremely hostile and had to be escorted out of the courtroom, which only proved the points I was attempting to make. This isn't what you're looking for, and but it was satisfying to me. Long story short, my aunt and step-grandpa got a restraining order against me for my grandma, even though I was actually protecting my grams from them, and we were both crying as I was forced to leave the house. The cops never asked my grandma, who was in her right mind, if any of it was true. My own strip mall lawyer didn't believe me, because why should he? I was calm the entire time on the stand and answered everyone calmly. My step-grandpa was hateful and basically used the time to repeat every awful lie he said about me my whole life that had nothing to do with how I treated my grandma. My aunt gets on the stand and her responses are filled with hate and jealousy. I couldn't really see her face because my lawyer was in front of me most of the time. We waited for the judge and my lawyer told me even if the judge agreed with me, that wouldn't make them let me see my grandma again. So my best chance was to settle before the verdict with the stipulation that I have visitation rights and a schedule. I said that's fine, but make sure you tell them if I win I will sue them for falsely accusing me to get all my money back. They agreed to settle the matter, and as we continued to wait, their lawyer and the elder care advocate were chatting and laughing with me while they sat there pouting in silence. It wasn't one mic drop moment, but it was satisfying. After, my lawyer admitted he didn't believe they were making it up until my aunt was on the stand, and the look on her face was just so hateful and jealous every time she looked in my direction. In all, another of those I was waiting for my day in traffic court stories. The case involved a guy who'd parked too far from the curb, and an old lady making a right-hand turn had rear-ended his car because the sun was in her eyes and she couldn't tell he was sticking out into the road. He's representing himself and is clearly some kind of Perry Mason fanboy, coming in with a folder full of documents, trying to use lots of legalese when talking to the judge, etc. He's apparently decided his best defense is to discredit the cop, and to this end he's brought in a copy of the police report which he insists on submitting into evidence so he can attack it. The judge told him police reports weren't admissible as evidence, but he insisted, going back and forth with the judge several times, until he annoyed the judge enough for him to finally agree, at which point he immediately banged his gavel and declared guilty, and explained to Mr. Mason that hearsay evidence wasn't submissible, but in this case contained her direct measurements of the distance between the curb and Perry's tires. Therefore he'd just submitted incontrovertible proof of his guilt. Other highlights of that day included a lawyer trying to defend her third DUI, based on her value to the community, who the judge gave a stern dressing down to, and a guy who'd fled from a highway traffic stop not because he had a warrant, but because he had too many speeding tickets. He led a high-speed chase into a residential neighborhood, where he drove across someone's lawn and jumped out of the car, which continued across the street and totaled a parked car. He was found later hiding in someone's basement, so all told he managed to turn a speeding ticket and possible suspension into getting dragged into court in chains and orange jumpsuit to face trespassing, breaking and entering, and multiple reckless endangerment charges on top of his moving violations. I like to study law, and have fought 4 out of my 5 tickets that I ever been given. One of the ones that I fought went like this: was given a ticket for reckless driving and the note said rapid/unsafe acceleration, failure to signal for lane change, speeding, paced, rapid/unsafe lane change. Cop claimed he was being nice by doing the reckless ticket and not all the other ones. I guess he hopes this gets me to admit guilt and not fight it, but in reality, a reckless driving is worse than all those combined. In court, and the cop states all his lies about everything he claimed I did. I admit I did rapidly change lanes, but it was to avoid an accident of the driver texting at green light and not moving. I then state I have an SD card with my dash cam footage, and that was my big moment. The judge asks if she needs to really watch it. Then the cop just stares like a deer in the headlights. We go on break. Judge watches video. We get back into the courtroom. Judge states she watched the video and just dismisses the ticket. I also had filed a complaint against the cop for his actions and harassment towards me, and the real reason he gave me a ticket. Video shows a normal car leaving a home with lights on and seatbelt clicking. Point shows me driving speed limit with no unsafe speed changes. Shows me changing lanes rapidly to avoid hitting a standing car in the middle of the road. Shows me pulling into parking lot. Edit. And if anyone cares, I work second/third shift and live 5 miles from the edge of a city. I went shopping on my way home from work and forgot my credit card, so left my items with the clerk and went home to get my card. Guess the cop saw me drive into my roadway, then back out moments later. I feel he also didn't like my engine noise. Yeah, I was going 60 miles per hour in third gear, well below the limit, and I like to have the torque on my little 1.5L engine. So yes, I changed lines to avoid rear-ending the person. The signal was heard in the video too. Wasn't speeding and never had any fast accelerations. I saw the cop pull out as I went past the stoplight, and he followed me for 4 miles to the Walmart parking lot. No lights as I get out of my car and start walking, and his flashes his lights and I keep walking. I didn't know he was actually following me. He then yells at me and I see he is talking to me, so I turn around and come back to my car. What are you doing? I'm shopping at Walmart. Why are you driving like it's the Daytona 500? Camera cuts off at this point. It only records like 1 minute after power is off on the car. I had windows down though, so you could hear. Oh. I thought the limit was 60, 45, 55, coming down the road. Did they change it? You are going to kill someone driving like that. Nobody out at 3 AM is up to any good anyways. Why do you have a sleeping bag in your car and that large box? I work second shift and I can't travel. Anyways, I need to get my stuff from the store. So we good. Can I see what's in the box? No reason to. I just would like to get my stuff from the store. I have cold items left out. I forgot my credit card and it's just sitting in there. Let me search your car first and then we'll see if you can get into the store. This goes on for 5 minutes and I finally did the now cliche YouTube thing. Am I being detained or am I free to go? Detained. You can't be driving crazy like that. You will kill someone. Can I search your car now? No, you cannot. If you think I have drugs, call for a dog. 5 minutes goes on of the back and forth. Well, I guess I'll have to write you a ticket. But if you let me see what's in that box and under that sleeping bag, I could let you off with a warning. A warning for what? You were driving like a race car driver out there. You could kill someone. Okay, I will take the ticket. Well, it'll just get you for 1 ticket instead of insert all the crap here. That was about the time I learned to hate traffic cops. They serve almost no real use other than to harass people. I swear he was acting like he was on Cops and gonna get drug bust of the decade of like 5 grams or something. Haha. I'm corporate counsel, so I don't plead directly. Do have some stories, though. Hour-long construction mediation exercise in which a contractor had stopped work due to non-pay and the owner of the project had stopped pay due to non-work. At this point the project was a few million over budget, but switching contractors would also prove expensive. There were 3 people on each team, and ours represented the owner. After 40 minutes of arguing over who did what, who owes what to whom, who can go do what to themselves, we were still $5 million apart. So I blurted out a number, $11 million. You finish the work. My colleagues concluded the negotiation as follows. A. $11.5 million. Point B. $11.2 million. Point A. $11.3 million. Point B. Deal. We settled with 15 minutes to spare. Point judging the 2L moot as a pair of 3Ls. Facts dealt with responsibility of a mining corporation for failure to defend a local village from bandits. The first to plead on behalf of the company argued that the company could not be held liable for the actions of a third-party contracted security team, given that the company had no say as to their training, equipment, and instructions. His partner then argued that the company should not be liable because they employed best practices in ensuring their contracted security were properly trained, equipped, and instructed. We didn't render a judgment, but we all know who won that point. During an oral pleading for a class actions course, a colleague for the defense argued that the plaintiffs had no case because a product cannot be considered effective if improperly assembled or used by the buyer. He proceeded to flip a mock-up of the product to crib upside down and emphatically stated, "If I blatantly ignore the instructions, then go ahead and use this thing upside down. The product is not the defect in this equation." That team got a solid grade. I recently had to argue a motion for summary judgment in New Jersey. By background, plaintiff was walking on a sidewalk to get to work from a bus station. We were commercial tenants at a corner building, and our client is a big electronics name, so the building has their name on it, but it's still owned by another entity and we don't lease the entire building. So there are other commercial tenants. It snowed 2 days before the accident, and the property owner never cleaned the sidewalk of snow and ice, which commercial property owners are required to do in New Jersey. So plaintiff had to walk onto the road and, at the neighboring property, tried to use the apron for their driveway to get back onto the sidewalk, and she slipped and fell. I argued a motion for summary judgment where we had 6 arguments, but the one I was really banking on was that we were tenants in a multi-tenant commercial building and, based on NJ case law, short of a provision in the lease agreement, we were not responsible for sidewalk cleaning. Plaintiff argued that we never produced a witness who discussed the other tenants. Plaintiff's counsel never deposed our property owner, even though they were a party to the case. I started arguing that, even if there is no testimony regarding other tenants, that my brief in support lists other tenants who verified to me they were in the property at the time of the accident. Plaintiff began arguing that it is not enough because there is no evidence in the record. I responded that, even if that is true, based on the lease agreement alone, plaintiff is aware that we did not control the entire building. That's when the judge looked at plaintiff's counsel and asked, "Do you at least agree that my client did not have sole control of the entire building?" Plaintiff said that, based solely on the lease agreement, it would seem that way. The judge asked if I had anything to add. I said no, and just sat right back down. The judge then turned back to plaintiff and said, "Assuming I deny their motion, how do you plan to attach any liability to them?" Trial was starting the following week and the court was not allowing additional time for more discovery. Plaintiff's counsel, to his credit, honestly answered that he did not know, since he could not show us liable either through the lease agreement and there was no time to request another witness from us to discuss snow removal at the property. Our original witness did not know anything about snow removal at the property and we were banking on the property owner being deposed and explaining that it was them. But as I said, plaintiff never deposed them before the motions were due to be filed. The motion was argued on a Thursday, and by Monday my motion was granted. But I had gotten my last speeding ticket several years ago while I was passing a driver going -30 km/h under the limit during a time where major arteries were closed, and I was just getting home and passed him and peaked out at +20 km/h as I overtook. At the time I explained all this to the officer and how the driver was dangerously slow. I had no chance to pass due to the speed of other cars, and I was overtaking him for safety and just to get home in a less stressful manner. He handed me a lower speed ticket and said to go fight it, and he wouldn't show up. I go to fight it months later in court, and there's a plea section before you go to trial. Basically meet with the prosecution and see if they can reduce the charges. Most people there were facing holding a cell phone while driving charge that's like 4 points and $500 here, so they were all pleading down. The prosecution probably thinking I didn't have a lot of court experience or legal knowledge, tried to intimidate me into pleading. I kind of shot him a side eye and said I'll got to trial, as I figured my explanation for passing at the very least was good enough, even if the officer showed up. So when they went to call the officer and he wasn't there, the police and legal staff all looked at me like I knew what was up. It wasn't 100% arrest my case moment, but my proudest court moment. I found that a plaintiff had hidden the fact that, when she first moved to the country, she was charged with serious crimes. She had turned state's evidence and testified against the cartel. That was actually how she got her citizenship, as part of her plea, because she could never go back home. So, when she was granted citizenship, she adopted a new name and began her life as an American citizen. There was literally no record of any of this on background checks, because her name wasn't connected, and she did not have a social before the name change, etc. Now, all the other lawyers on here are saying, yes, but she wasn't convicted, and even if she had been, its admissibility is very limited, and only within 10 years, etc. None of that mattered for my purposes, because I wasn't trying to get the criminal charge admitted or anything like that. Instead, I was showing that she had lied on her pre-employment screening with my client, who had run a background check, and as part of that asked for aliases, convictions, and even specific types of charges. But the best part is that I knew she would unravel, as would her counsel, when I brought this up. OPC exploded with objections, caused a scene, the witness stammered and lied, then corrected, then lied, then recanted, and basically melted down in the most incredible fashion. This case depended entirely on her credibility, which was in shreds. Best of all, she hadn't told her lawyer any of that backstory, and he had been so self-righteous about her and his case. It visibly ruined him. Not a lawyer, but occasionally act as a union representative for firefighters in disciplinary matters, arbitrations, and a standby when they give depositions or are witnesses in court cases, etc. I went to federal court for a case of a department and several chiefs who were accused of union busting for firing a union vice president for supposedly lying, having no water in his fire truck, and being out of his area. The chiefs said they happened to be randomly driving around and decided to visit the station where this man was assigned because they happened to be in the area and found the truck out of water and couldn't find the crew because they were out somewhere they weren't supposed to be. This case had gone on for a while and the firefighter in question had already been rehired somewhere else and even promoted there. In the case files was an email on the department computer where one chief basically said, "Let's go to the station where the guy in question is working so we can mess with him." They had to know, or should have known, we had that, but it was kind of exciting to see them backpedal after we showed it to them. Case closed in favor of the firefighter, and two chiefs retired right after. Second was a court case where a paramedic had pronounced someone dead at the scene of a crash. The driver was being charged with DUI homicide in the case. The medic had written in his report words to the effect of there were so many broken beer bottles on scene it was hard to smell alcohol on the driver's breath. The lawyer went to questioning the medic and was a dick and ended up implying incompetence because he hadn't documented if the driver had been drinking or not. The medic holds up his report that he had a copy of for reference and read what it said. The lawyer looked at his copy and was flustered and did the no further questions thing and looked like even more of a dick. There were a few more fun court and arbitration ones, but these two were the best I think. I'm not a lawyer, however law has always interested me. Represented myself for a traffic ticket in Boone, North Carolina where the cop wasn't the nicest. Had dash cam audio, and I was supposedly caught doing 45 over in a 45. Well, here's the thing, my car, an 07 Civic, won't go over 65 without making it rattle and undrivable, was on way to get it fixed. The officer approached me, and I handed my NCCHP and license and was legitimately confused and asked what his reason was. He said he was sick of college kids and driving on mommy and daddy's dime and speeding. I said, "Sir, I wasn't speeding, it was the car beside me." He then questioned what a college kid. I was 23 and started college late, saved from 17 to 20 to not do loans, and went to community college first. I said, excuse me sir, first of all I'm not a kid, second of all I'm following the law and have a permit. He illegally disarmed me and searched me. I told him to F himself. He said he would see me and my family rot. Went to first court date, explained to DA and the DA didn't buy it. The look on his face after he lied and said how I was resisting detainment when the judge heard the audio and apologized to me saying it should have never happened that way. I also found the guy who was actually speeding. 2010 black Challenger, lived in same apartment and gladly came on my behalf, and last I heard the officer got his cert stripped and is being investigated for embezzlement. Not during trial, but a pretrial. When my client was arraigned in this case, he was also out on $35,000 bail from another jurisdiction for a felony assault, but this same prosecutor failed to bring it up and argue for bail in this case. I know the judge saw the pending charge, but she didn't particularly care given all of the arguments that I made at arraignment. He was released without bail in this case. We were just setting the case over about 45 days, but the baby prosecutor, a second-year intern at the prosecutor's office, demanded that the judge revisit conditions of release for my client. Normally, you need some kind of change in circumstances to do that, and there hadn't been any. Since arraignment on this case point, we went through the short set over procedure and got the new court date. The judge handed the order for the new date down and said we could go. That's when the prosecutor reminded her that she wanted to bring up conditions of release. The judge said, as disinterestedly as possible, "Oh, that's right. Go ahead then." She just looked at her other files the entire time the prosecutor talked. The prosecutor said that she had neglected to raise the issue of the other assault case and wanted $100,000 bail in our case. I saw the judge roll her eyes and then ask me if I had anything to say. I made a quick argument knowing what the judge was thinking, and then the judge looked at the prosecutor and just said, "I'm not going to do that."